Mhm.
Yeah, request before the court is the matter, Manoj.
Yes.
On 9th of April, Lordship made the order in the matter of SFIO, setting aside the bail granted by the High Court and to settle within 7 days' time.
Would it not be better if we both are there?
Yes, Manoj. In fact, I wanted listing of the matter tomorrow.
But that can't be done. That can't be done unless it is mentioned before the bench.
The difficulty is I want listing only tomorrow because
That's
today I can't mention before any other bench.
That's true, sir. But the regular bench will be available tomorrow. Only today probably the other honorable sister judge is not available.
Your Lordships are right. Only one small difficulty I can mention to your Lordship court. The court made the order on 9/4 saying within 7 days you surrender. Today is the last day. Application is filed to surrender. That's the only request I wanted to make to your Lordship's court. I'm not requesting the court to grant any extension today, but the IA can be come up tomorrow before the bench. That's the only request, folks.
That will not be proper when the bench is not there. It's only a temporary arrangement as the bench is not there.
As per the Supreme Court rules, my lords, your Lordships have the power to grant extension or enlargement of the period which the court has made by some judicial order.
You mention the matter tomorrow before the regular bench. Bench will be available. It's only today the difficulty is that the other honorable
of not requesting the court to list because today is the last day. That's the only anxiety that I had. Nothing beyond it.
That I can just inform the sister judge that it was mentioned and then let it be taken tomorrow.
Again tomorrow. Much obliged. Please, Your Lordship. Grateful.
Yes, it is at the instance of wife.
Both the petitioner and respondent, wife and husband both are filing this petition. Right now, they are requesting to defer this to mediation because they might be looking for a settlement.
If this is transfer petition, notices are not yet issued.
Yes, Your Lordship.
So we'll issue the notice to the other side. Let the other side come before this court. You are seeking transfer from one place to other, no?
Yes, Your Lordship.
This is from Kheda, Gujarat to Patiala House, Delhi. What is the difficulty?
The difficulty is, Your Lordship, both the wife and the husband, they have shifted to US for employment purpose, and they would not be able to, make the travel every time whenever in the district. It is far off from the main state, the city. So that's why they have to come to Delhi.
Notice, let it be make it returnable early. Meantime, you can serve. We permit you to serve by way of Dasti also.
Yes, Lord.
No, notice returnable within 2 weeks. The petitioner is permitted to serve the respondent by way of Dasti service along with the usual mode of service and to place on record the proof of service.
Obliged, Lordship.
My lords, I appear for the wife.
This is from Kolhapur, Maharashtra to Karnataka.
Yes, my lords.
HON'BLE.
Yes, my lords.
And when you got the knowledge of the proceeding initiated by the respondent?
My lords, there are no summons on record, but the petition itself, the petition itself was filed in June 2024.
Yes, so this proceeding was initiated sometime on 22nd of June 24. And what was the mode of your knowledge of this proceeding? When it came to your knowledge, either way of notice, summons, whatsoever it may be, what is the statement to that respect?
My lords, the summons are not on record, but the client must have received a notice.
Where is that statement that the knowledge by way of some information?
In SCLST matter and the files that we received from the client were limited. However, the petition itself.
The client is not supposed to inform the counsel about the knowledge.
This file came through SCLST and it's been a little difficult to.
You have no occasion to seek instructions from the client?
No, my lords, I did. However, the only thing that she knows is that she'd received, the only thing that she knew was that she'd received the petition and that the proceedings are ongoing.
When
However,
was
she
when
has
was the marriage solemnized between the couple?
2013, my lords, 13th May 2013.
Any issue of the out of the wedlock?
My lords, there's one child born on 3rd June 2014, a son. Right now, he's under the care of his mother.
Now you are with your parents?
Yes, my lords.
The counsel for the petitioner. The petitioner seeks transfer of the proceeding, namely so and so, initiated at the instance of the respondent husband from so and so place to so and so place on the ground of hardships. It is submitted by the Land Council that marriage between the parties was solemnized in year 2013 and the couple was blessed with a son. It is further submitted that due to the harassment and ill treatment by the respondent husband, the petitioner was constrained to leave her matrimonial home on or about 4/4/24 and started residing with her parents. Presently, the petitioner is being supported by her parents. What are they doing? And the parents are not in a position to provide any financial support to the petitioner. As such, the transfer is sought for. Notice 4 weeks meantime stay.
Right, my lords.
Lordship, the marriage was solemnized on January 23. After that,
Any issue out of wedlock?
Lordship,
2003,
23, Lordship,
23.
2023.
Any issue out of wedlock?
Dowry demand and
No, any issue out of the wedlock? No issue.
some of the home affairs only, otherwise not.
Any child born out of the marriage?
Lordship, no.
No.
No, Lordship.
Okay.
No, Lordship.
Now she is with her parents?
Yes, Lordship. They are the poor persons, they cannot financially. Lordship, 1200 kilometers from the.
Yes. For the counsel for petitioner, the petitioner wife seeks transfer of the proceeding initiated at the instance of respondent husband from so and so place to so and so place. The young counsel submits that due to continuous harassment and ill treatment, petitioner was constrained to leave her matrimonial home and now being supported by her parents who are not financially sound so as to provide any financial support to the petitioner. The council further submits that the distance between two places is nearly 1200 kilometers and as such it is very difficult for the petitioner wife to travel from her place of residence to attend the proceeding.
Stay, Lordship.
Notice 4 weeks meantime.
Lordship, kindly, if stay not granted, then if the order passed by the Delhi court, then it should be very panic for the petitioner to.
Sir, meantime stay.
The distance between Guwahati and Mumbai is 2600 kilometers, and the petitioner has
Marriage?
medical condition. Marriage happened in 21 minutes, 18 July 2021.
21.
Yes, Malats. They have been separated from June 2023. We received the summons on
Seeking
27th.
transfer on the
February.
ground of hardship, particularly the ill health of the petitioner. Is not permitting the petitioner to travel the distance, which is nearly
2600 kilometers, Manoj.
2,600 kilometers. Notice 4 weeks meantime stay.
Right.
Your Lordship, I appear for the wife. I'm seeking transfer from Narnaul, Haryana to Alwar, Rajasthan.
To
Alwar, Rajasthan.
Narnal, Haryana, to Alwar, Rajasthan. 100 kilometers, distance is 100 kilometers.
Yes, Your Lordship, but the wife has been subject to cruelty and sexual assault by the brother of the husband. There is a threat to her safety, Your Lordship. An FIR has already been registered in this regard.
Where is the copy of the FIR?
We'll annex it by the next date.
Why it was not annexed?
I was supposed to bring it, but it was not available, Your Lordship.
No, there was some difficulty and some misdeed by the brother-in-law. What was the reason? I mean, for you to get separated from your husband?
Abuse, Your Lordship.
Where is that?
Harassment.
Where is that? That she was also subjected to ill treatment by husband?
List of dates.
Marriage was compelled to return and deeply distressed by physical and mental episodes.
Respondent was consistently treated the petitioner with cruelty. The respondent's behavior towards the petitioner was perpetually harsh, and she was subject to harassment and torture.
But what you orally submitted is not finding place in your petition that
Oh, Your Lordship.
there was an attempt of misdeed and the brother-in-law posed something. Mother-in-law forcibly administered medicine so and so while she was unconscious by her brother. Okay.
Your Lordship, please have a look at page.
Yes, yes, it is there. Notice 4 weeks meantime stay.
Meanwhile, can we have stay on the?
Yes.
Much obliged, Your Lordship.
Your Lordship, I am appearing on behalf of wife and seeking transfer from Chittorgarh to Indore.
Marriage
So marriage happened on 1st May 2023.
23.
Yes,
Within a year there was a matrimonial discord.
yes, Your Lordship.
Serious harassment, lodged FIR, 25, so and so, yes. But the proceeding initiated at the instance of respondent is prior to your lodgement of report.
Your Lordship, but then,
So is it not your counterblast to that proceeding?
oh, Your Lordship,
Why no? Take the dates on record. Respondent files CM number 258 of 24 before Principal Judge Chittorgarh against petitioner for dissolving the marriage on the ground of desertion by wife. And now you state in paragraph 5 that serious harassment and lodged FIR of 19 of 2025 on 29 January 25. Take these dates as it is.
in the meantime, I was trying to resolve the disputes, but when they were not resolved, I had to take.
So you lodge a report.
Your Lordship, I was being subjected to cruelty, but then at the
That
same
could
time.
have that could have been earlier to his proceeding. if that was the case, if you are subjected to ill treatment, harassment, any mistake by the husband or in-laws, you could have immediately reported it to the police. So that could have been a first instance, not something which is after the respondent files the proceeding.
Your Lordship, I was trying to revive my marriage in the meantime. Also, Lordship, if you will notice, I have written in my pleadings that once I had gone for the matter to Chittorgarh, at that time, the respondent threatened me. So there is a serious danger to my life.
The counsel for the petitioner takes transfers fine, so counsel submits that. Though the petitioner made an attempt to attend the proceeding initiated at the instance of a respondent at Chittorgarh, right? But subjected to certain threats as such. Petitioner will not be in a position to attend the proceeding at Chittorgarh. For weeks, meantime stay.
Much obliged, Your Lordship.
Also,
Please, Your Lordship. Well, this is a transfer petition filed by the petitioner wife seeking transfer of the divorce petition filed by the respondent from Hisar to Chandauli Family Court, Uttar Pradesh. Well, the distance is 1,000.
madam, that is initiated in
My
2019.
lords, I'll tell. My lords,
What happened?
my lords, what happened? The petitioner is a constable in CRPF, my lords. Till May 2023, since she was posted in Delhi, she was appearing and contesting the petition in Hisar. My lords, but now she has been transferred after June 2023. It was inconvenient for her to avail, my lords, the.
Right, but then after 23, why you have not approached immediately? Now it seems last
My lords,
practically 2
yes, my lords.
years.
Well, that also I've written. My lords, 2023, somehow she managed to appear before the concerned family court. My lords, but afterwards she came to Delhi and approached the office of the lawyer. The lawyer said since the mediation between the party was going on in the family court, Hisar, therefore the transfer petition will not be entertained. Therefore, she waited, my lords. Then she returned to the. My lords, there is a daughter also 5 years old.
The counsel. Transfer is sought for from so and so place to so and so place. It is submitted by the learned counsel that the petitioner dutifully attended the proceedings initiated at the instance of respondent in year 19 till year.
May 2023, my lords. Thereafter, still date, my lords.
Please wait, madam.
My apology, my
Till
lords.
May 2023. In June 23, the petitioner, who is employed in armed forces.
No, but she's already, in 2018 only, she's already, my lords, transferred. Once she was transferred. I'm sorry, my lords.
Employed in armed forces, that is CRPF, was subjected to transfer from Hisar to
Delhi, my lords.
Chakia, Chandauli, UP.
My lords, from Delhi to.
In June 23, transferred to Chakia, Chandauli,
Yes, my
UP.
lords. Yes, my lords. Please, your lordships.
Is it that statement
my
is
lords.
wrong?
No, my lords.
We are recording that.
My humble apology, my lords.
Chakia, Chandauli, UP. And then it was very difficult for the petitioner to attend the proceeding. due to long distance as well as the other ground, namely a small baby of 3 years having some health problems. As such, the petitioner was unable to attend the proceeding. Meantime, as some attempts were made to explore the possibility of an amicable settlement through mediation, the counsel of the petitioner asked the petitioner to wait for some time. And when the petitioner found that there are no chances of any amicable settlement through mediation, the petitioner was left with no choice but to approach this court for seeking transfer of the proceedings. Notice 4 weeks, meantime stay.
I'm deeply obliged, my lords.
Please, my lord, subject to appear on behalf of petitioner in this matter.
Notice is already issued?
My lord's notice has been issued in another matter.
Another matter?
Yes, my lord.
What is that matter?
My lord, that's a transfer of divorce, restitution, section 9 petition, my lord. Restitution of conjugal rights. My lords, kindly have this order.
Yeah, it's there. 1425.
Yes, my lords.
That is proceeding case number 1769 of 23.
No, my lords, it's transfer petition civil 815 of 2025.
Right? The proceeding in that matter is the proceeding case number 1769 of 23.
Yes, my restitution of conjugal rights.
Yes, transfer is sought for on the ground of hardship. The council further submits that and another proceeding between the very parties, namely case number 1769 of 23, pending before the Principal Judge Family Court of Varanasi, is also sought to be transferred by way of transfer petition number 815 of 25 and by the order dated 1425, notice is issued in the said transfer petition. Accordingly, notice 4 weeks.
My lord, stay.
And to be tagged along with that petition, transfer petition number so and so.
Grateful, my lord.
Not necessary, you can serve that. You'll only tag along with that matter.
Yes, my lord.
You serve the other side. They are now aware that the other petition is pending. They will come before this court.
Grateful, my lord.
Plus, I represent the petitioner wife, Milads. But this petition, Milads, has been filed for seeking transfer of divorce proceedings from Ghaziabad courts to Delhi, Milads. The marriage was solemnized on 22nd July 1999, Milads. There are a series of litigations already pending before the Delhi District Courts as well as the Honorable High Court between the parties, Milads. I have filed a petition under DV petition as well as 498A trial is going on. It is listed for evidence. Now, after 10 years, Milads, the husband has filed this divorce proceedings as a counter blast, Milads, at Ghaziabad court. There's a daughter, Milads.
Yes, no, hardship. It is also submitted by the council that there is a series of petitions between as the parties, as there is a serious matrimonial discord between the parties, and the same led to series of proceedings initiated by respective parties. weeks meantime stay.
Deeply obliged.
By this petition, my lord, the petitioner wife seeks transfer of the section 9 petition, my lord, from
Dantewada, Chhattisgarh to Odisha.
Odisha Raj. Distance between 500 kilometers, but this is the border area, my lord. and
25.
She has two
Distance
daughters.
is
Sorry, my lord.
5 kilometers.
500 kilometers. my lord,
500
but
kilometers.
border area, therefore, my lord. She is praying and she has two daughters, my lord, younger daughter.
So what are the ages of these daughters?
My lord, 19 and 18, my lord.
19 and 18. When was the marriage ceremony?
2004, my lord, and my lord.
4, and this
Yes, my lord, and after
case is initiated in 25.
my lord, after she left the house, my lord, in August 2024, thereafter filed DB Act case, my lord.
So now you are staying with your parents.
Yes, my lord. I'm staying
Where is that statement?
in ground, I have mentioned, my lord.
Conduct is government employee earns income of 50,000. In which department he works? Darshan Rao, Dantewada. You stated that he is working in some government organization.
Yes, my lord.
Yes, 4 weeks meantime.
Please, my lord.
Please, my lords. I'm seeking transfer from. I'm appearing for wife, your lordship, and seeking transfer of the case divorce petition filed by the respondent husband in
Ghaziabad to Court of Kolkata, West Bengal. This is a 24 proceeding. When you got the knowledge of this proceeding?
Your lordship.
The proceeding initiated at the instance of respondent husband, of which transfer is sought for. When you got knowledge of this proceeding and by what way?
Your lordship, I was served notice.
Where is that statement?
Lordship, I have annexed a copy. Page number 11.
Page 11. Okay. So you attended this date, 24/12/24?
Your lordship.
Are you sure about the dates?
Yes, your lordship.
Your petition is filed on 6/12/24.
Filed the case at 28th May 2024 after 2 years of marriage.
Right. Therefore, we asked you about the knowledge of the proceeding. You submitted that page 11 is the copy of the notice, which is of 24/12/24. Your petition is much prior to that, so even before 24/12 notice, whether you were served earlier also.
Also, there is some mismatch in the dates.
Major mismatch. So it clearly reveals that before this notice, you were in receipt of knowledge of the proceeding, and therefore you approached this court on 6/12/24. And this 24/12 notice seems to be a second or third notice.
Your lordship can refer to page number 22.
22, okay. What is it?
It is a case status, your lordship. Clearly indicates that the next hearing date is 21st April 2025.
Right. So meaning thereby, before 24/12 notice, you were made aware by an earlier notice. So why you approach this court belatedly then?
So client was not aware about proceeding.
It can't be. You approach this court on 6/12, meaning thereby, you had the knowledge before 6/12, therefore you approach this court. And subsequently, this notice, page 11, is received by you. Isn't it? If you take these dates, on face of these dates, 24/12 is post 6/12. So when you approach this court, you have the knowledge. When is the next date?
Next date is your lordship in April 2025, 21st April.
Where is that statement at least, or it is only an information received by you?
At page 22, your lordship. Page status.
Next hearing date.
Last is including status and next hearing date.
So, initiated, filed on 28th May. Probably notice must have been issued immediately. Served you, then no statement. Anyway, yes, it's 21 notice. 4 weeks, meantime stay.
Please, my lord, I'm in item 1613. I'm for the wife. Transfer is sought from Rewari, Haryana to Ladnu, Rajasthan. Distance is 273 kilometers. I am residing with my mother. I am unemployed. And my father has passed away, my lord. There's an
Marriage
FIR
was
pending in
solemnized
Bangalore.
when? 20?
2024, my lord, January 20th.
No issue.
No issue, my lord.
About this incident, 15/5/24, registered against respondent husband.
I'm sorry, my lord.
Any statement? Come to page 3, 2.5. The
Yes, my lord.
respondent
The incident of 15th of,
so and so
15th of
driving
May.
recklessly, broke the toll barrier, so and so police formed barricade, managed to intercept, however, respondent ran away. About
Yes,
this
my lord.
incident, any report was lodged by
My lord,
police
it does not
authorities?
it does not fall from the record. I'll seek instruction on this point, whether any FIR has been lodged. I'm grateful, my lord.
May I please your lordship? I am
Yes.
seeking transfer of this matrimonial dispute from Durg to Tis Hazari or any Delhi court, your lordship. The distance is about 1200 kilometers. I'm 53 years old. High blood pressure and medical grounds are also there, your lordship.
But you were served with a notice, page 15, sometime in your 23 itself,
Yeah, that's December 20.
26/11. So why you were waiting for 2 years?
Lordship, that was December 23. The notice itself is of 19 December.
Right.
26th of December. And meantime, your lordship, I'm a middle-aged woman, your lordship, and sought legal advice. And I had filed a domestic violence case prior to this. This was a subsequent proceeding by the respondent once I was subjected to cruelty, your lordship. That matter is already pending before Tis Hazari court, your lordship.
When is that statement?
That's in my list of dates, your lordship, on 30/10, page number D.
In year 1988. But till 22, everything was okay.
Hiccups were there, your lordship. It was not.
And 22, he retired from government job. So
Lordship.
thereafter, he started maltreating you. Is that your case?
My case is he has been doing it continuously, but then for the sake of family, your lordship, I had bared all this, but the things got worse post his retirement, your lordship.
Counsel submits that though the petitioner was subjected to ill treatment post marriage, but the petitioner made an attempt to maintain the family and cordial relations with the respondent husband. But as the ill treatment was unbearable, the petitioner filed a petition in year 23 under Section 12 of Domestic Violence Act before the learned Mahila Court, Tis Hazari, Delhi. And as a counterblast, this proceeding, the respondent husband initiated
December 23, your lordship.
initiated a proceeding, namely case number 95/23 under section 13(1)(a) of Hindu Marriage Act. Notice 4 weeks, meantime stay.
Much obliged, your lordship.
May I please, my lords. My lords, this petition has been filed by wife seeking transfer of divorce petition filed by husband from Visakhapatnam to Secunderabad, Telangana, my lords.
What is the age of the child?
My lords, he is 10-year-old today. My lords, in fact, the respondent left the matrimonial house and he abandoned us, my lords. In fact, my lords, during the subsistence of marriage, I was forced to get aborted also. The harassment was, I was harassed a lot, my lords. In fact, on the last date of hearing, when I approached the Vishakhapatnam court, I was threatened there also, my lords. And my lords, today it is difficult for me to travel along with my 10-year-old child, my lords, from Hyderabad to Vishakhapatnam. In
Now
fact,
you are supported by your parents.
my lords, I am working as an employee, but I am being taken care of by my parents also, because my income is not sufficient to maintain myself and my child. And my lords, in fact, I have filed an FIR which is pending before Chief Metropolitan Magistrate at Hyderabad. After that, he files this divorce petition in 2023. 3 years later, my lords, and he's harassing me, my lords.
Now
In fact,
you're
my lords,
working or
I am working as an employee, my lords, but my income is not sufficient. In fact, my lords, he is also appearing before, he has to appear before Magistrate Court in Secunderabad. Even we resided together in Secunderabad, my lords.
Hardship? No.
I am preparing for petitioner
Grateful.
my lord. I am, my lord, seeking transfer from Hardoi to Haldwani, my lord, Uttarakhand.
Age of the child?
4 years, my lord.
4 years. When was the marriage ceremony?
My lord, 2019, my lord. And my lord, petition filed in 2024. People of Nigeria.
Notice for which times.
Interim stay also. Oblige.
Filed by respondent husband from Junjunu, Rajasthan to
Junjunu,
Pataudi,
Rajasthan
Haryana.
to Pataudi.
Pataudi, Haryana. Millet's marriage was solemnized on 14 February 2014. Since 18th June 2019, the parties are living separately. There are multiple proceedings which are already going on in Pataudi, Haryana. And Millet's this present divorce proceedings have been filed by the respondent husband as a counterblast just to pressurize the
Age of the son? Child?
It's 5 years.
5 years.
Your respondent husband? Yes, Millet's 5 years.
It's 4 weeks. Intense.
My lords, I beg to appear. I beg to appear for the petitioner wife seeking transfer of the proceedings, divorce proceedings initiated by the husband from Indore to Jahanabad. These proceedings were initiated after receipt of summons from the police when I had gone to the Mahila Thana and lodged a complaint in Jahanabad. After receipt of the complaint, the husband has instituted these divorce proceedings in Indore, which is 1200 kilometers away from Jahanabad. And both of us are permanent residents of Jahanabad. I'm a 24-year-old unemployed woman.
No issue out of the wedlock?
No issue, my lords. No issue. I'm so grateful.
Lord, this is petition for transfer of case, section 10H, mean judicial separation case from Farrukhabad, Uttar Pradesh to Dwarka, Delhi. The marriage was solemnized on 12 July 2024. They are living separate from 8 February 2025. We have received the knowledge of this petition on 17th March 2025 through Indian Postal Service summons.
Marriage was solemnized sometime in July 24.
Yes.
What is the respondent doing in life?
He is senior manager in a MNC company in Gurgaon. He is living in Gurgaon, he is working in Gurgaon, but he has filed this petition in order to just harass me.
What about you? Any academic qualification? Not supporting you as a self-dependent lady, or?
But I am suffering from depression. I am a graduate lady. I am living with my parents in Mohan Garden, Delhi, Uttam Nagar.
Any report was lodged? You have stated in your petition that immediately after marriage, you were subjected to ill treatment under influence of liquor. The respondent was misbehaving with you. Then again,
No,
and so after so and so. So any report was made to
Your Lordship,
police?
we have not lodged any report. We were under the impression that good sense will prevail in the near future. We have tried each and everything to make this relationship and this marriage work. We have evidences also, we have each and everything, but till now we have not done anything. Even after receiving of the summons, we have tried our best efforts to mediate this matter through the family person.
So if he was carrying some bad habits, normally it will not be disclosed. Nobody will disclose that the person is carrying some bad habits.
Now, because
it will happen only in the movies, no? Having all these habits being disclosed.
We have all the evidences, but
taking the proposal.
We are thinking of having the best possibility of mediation till now also.
Notice 4 weeks.
Please.
Intense day.
Deeply obliged, Your Lordship.
Your Lordship, I am appearing for 5 petitioners in the matter: the mother-in-law, the father-in-law, the husband, the brother-in-law, and the wife of the brother-in-law. A domestic violence petition is filed in Farrukhabad. As of now, Your Lordship, the respondent is residing in Gurgaon and has initiated 3 proceedings after filing this DV petition in Farrukhabad. The first petition, which has been preferred in this matrimonial dispute,
issue notice. Let us see.
Your Lordship, the petition is listed on 18th April, so in case of mistake.
You can seek an adjournment now if there are series of petitions.
Your Lordship, if stay is granted, Your Lordship, then oblige, Your Lordship.
Please, my lord. Lordship, this is a transfer petition seeking transfer of a domestic violence case and a criminal case, which is. Am I audible, my lord?
Yes, yes, 498A, 323, 506, criminal
Please.
matter. Yes, so notice.
Lordship, I'm also seeking stay of the 2 proceedings. Those proceedings were initiated by me.
Notice 4 weeks. These are the criminal cases, madam. It is not only between the couple. Criminal cases where the other parties are also there. You must have cited some witnesses when you allege that you were subjected to this ill treatment, etc. Arising out of this, making a report leading to commission of offences under IP code.
Please, my lord.
Yes,
Lordship,
let them come before this. We'll see.
Very
4
well.
weeks.
Deeply obliged.
This matter, petitioner, although my lord, she is husband, but every time husband is not wrong, my lord. This case is, he is working as an Indian Air Force, my lord. It's very difficult for him to come frequently for this, my lord.
For weeks.
My lord, I say that the stay, why is
No.
required, my lord?
He is working in Air Force, able-bodied person.
That's then returnable notice.
4 weeks. You may serve, permitted to serve.
Just on returnable. Returnable notice matter will come early. Returnable notice. Notice returnable.
Yes, making the notice returnable. 4 weeks.
Lordship, the counsel appearing in this matter is held up in court 4. He's asked me to seek a passover.
No. And for the petitioner, even on second call after 4 weeks. It will be mentioned. Yes, and for the petitioner, even on second call after 4 weeks. Now wait for some time. Just now she mentioned.
Your Lordships, I'm for the petitioner.
Yes, there are certain
Your Lordships, yes, so.
defects being cured, not provided adequate court fees.
So your Lordships, I mean, I concede that we haven't been able to pay the court fees. Kindly grant us two more weeks. We'll file it in war footing.
At the request of the council, 2 weeks time granted to take effective steps so as to cure the defects.
Since 1702, I appear on behalf of the petitioner, my lords.
16 to 20 have been added, but council for petition has not filed amended memo of the party. Service is not complete on 17.
We'll do the needful in 2 weeks, my lords. We'll do the needful.
At the request of the council, 2 weeks time granted to take steps for service for an effective service of respond number 17 and 19, as well as for curing the defects.
Watch out.
I appear for the petitioner, Lords, as well as for respondent number 6 to 9. Lord, this is an application for transposition 22035, Lords. Lord, these respondents were original petitioner, Lords, but could not join the present petitioner at the time of filing.
There are certain defects. Council for petitioner not filed affidavit of justice service.
Lords, everyone is served, Lord.
Service of notice incomplete of respond number 5.
No, Lord, 6 it says. 5 it says. Lord, I have filed on behalf of 6 to 9, Lord, this transposition.
Wait a minute.
Yes, Lords. Notice is complete only with respect to 6, Lords, and for his behalf I filed this transposition application, Lords.
Respond number 6.
6 to 9, my lords. They were the original petitioner in the writ petition, my lords, but they could not join this present petitioner while filing the SLP, my lords. They have no knowledge, my lords. When they were served, my lords, they approached me, my lords, for transposing themselves as a petitioner, my lords.
All are served?
All are served, my lord. Everyone is served. Lords, office report says service of notice is incomplete on respondent number 6. Lords, I appear on behalf of 6. I filed this application and Wakalatnama also on behalf of 6.
The non-council submits it on an application, namely 47544 of 25. No, 22035 of 25.
Yes.
Seeking transposition of respond number 6 to 9 as petitioner number 5 to 8 notices were issued. And notices are duly served.
No, my lords, this notice of this application I have served to them. Advance notice I have served to state and state, my lords.
Your Lordship, I appear for respondent number 1 to 4 the state. Lordship, if I may just point out, IA number 475 is for
22035.
No, that is not even now. IA number 22035 transposition of 6 to 9.
I have served to the respondents, my lords. They are here.
Have you filed the proof of service?
They are here, my lords.
They are here.
After issuance of notice, I filed this IA, my lords. After issuance of notice, they filed Wakalatnama on behalf of state, my lords. So I have served them, my lords. Proof of service is there, my lords, at page 7.
With respect to the transposition application, Your Lordship, we have the state has no objection.
The application 2203525, the council submits that these respondents are duly served and being represented by the council. The copy of the Wakalatnama is also filed. Is annexed to the application as a service of proof. the office to verify and case the objection no more survives, and if the objection no more survives, let the matter be listed before the court for further orders. Yes, who has filed this? Implement of which party? Implement, wait a minute. Then notice will have to be issued on this. Yes, issue notice on the application for implement making the same returnable after 4 weeks.
Lords, transposition is allowed, Lord?
Yes, transposition application.
Lords will list then all the matter before the court for final hearing, my Lord.
No, but now this application notice.
Lords, along with the main matter, it can be heard.
Let it be served and then.
Please, Lords. Lords is giving some date, Lords.
List after 4 weeks.
Date, Lords.
Because it's an implement application. So what happened is that was in the High Court, state of Maharashtra was a party.
Right.
But due to my inadvertence, I could not hire him as a party. Because the state of the matter is also what has happened is that the petitioner is a prisoner who has been in custody for about 32 years. And he's a native of state of Uttar Pradesh, but a prisoner of Maharashtra. We sought his reciprocal transfer from state of Maharashtra to state of Uttar Pradesh. Now, that having been rejected, the representation having been rejected by the state of UP because they did not issue us NOC, we filed a writ petition before the Allahabad High Court. In Allahabad High Court, the state of Maharashtra was a party because Maharashtra is a necessary party for this person to have been sent from Maharashtra to state of Uttar Pradesh.
Lordship, I am appearing for respondent. This issue has been settled 23rd August 2024. Again, he filed a writ petition before High Court. That was dismissed. Fact was mentioned there.
So the High Court, the state of Maharashtra was not made party.
State of Maharashtra was party. Lordship, that still a delay in justice. Still is not made party before this court. There was no direction in impugned judgment, but
Sorry.
Lordship, my limited prayer is, Lordship, place this application before court along with your main matter.
Wait a minute.
Writ petition in the SLP, the writ petition is at page number, it is at page number 143 in the SLP and page number 7 of the IA is the memo party. Respondent number 6 is state of Maharashtra. It was due to my inadvertence that he could not be allowed over here.
Lordship, page 126.
Why is addressing on merits?
Cited this issue.
Addressing on merits, what is the purpose?
You are seeking your transfer from citizen to UP.
Please.
But the apex court declined that request.
Thereafter, so what happens that previously I had filed Article 32. I'll explain.
Right.
Article 32 was filed for the reason that I was also undergoing a trial in state of Uttar Pradesh.
But the statement before the court was neither the UP government nor state of Maharashtra for their tourist. But the reason is found by the court.
After your lordships have considered and have issued notice as state, so what happened is that was state of Maharashtra because filed affidavit to your lordship's court. Because later on, I filed an RTI, and in the month of October, it was revealed that Maharashtra produced a notice. Now, with that NOC clause, we filed because there was an NOC by the state of Maharashtra, and there was no permission granted by the state of Uttar Pradesh. So we filed writ petition in the state of Uttar Pradesh, saying now there is already an NOC. So therefore,
even though the state of Maharashtra granted NOC, the state of UP categorically stated they are not ready.
So because the your lordships have discussed a petition on the ground, the state of Maharashtra was also not ready.
That is one of the grounds. Please come to the order. Commissioner, however, seeks transfer to Maharashtra. The state of Maharashtra is silent for the matter in spite of repeated opportunities. This is about the state of Maharashtra.
Yes,
all the same, the counter affidavit of the state of UP has filed categorically stating they are not prepared to take petitioner as he is not requiring. So how this court can then?
So your lordships have entertained because in the year 2021 by a government order issued by Chief Secretary. Later on, one district jail officer had filed an affidavit saying that we are not doing. So because that factum and this factum and the factum coupled with the fact that the state of Maharashtra has now issued it. So therefore, we filed a writ petition saying that it is the government order which shall prevail over the affidavit which has been filed by the superintendent of prison.
What prevented to get that order when you filed a petition? You got this all
RTI because I got all this.
So that there was no prohibition for you to file application when you were in prison. For that very information.
I'm in custody for 33 years. 3 years, I'm 72 years.
Let's see when the notice is issued.
It is issued recently in this matter. In the month of January, it was issued.
January 15.
It was an inadvertence clause, so it caught my eye in the month of March. I was under the impression the matter was showing to be listed. So I went and I checked the state of Maharashtra not. And then I noticed the state of Maharashtra has not been added party to my.
But even assuming that state of Maharashtra having no objection, fact remains that the state of UP was not inclined
now
to accept your request as a prisoner in UP.
At juncture, it may not have been. But now the situation has changed, some have changed, because both the FCs are there in my hand. So with those,
where is the state of UP?
I'll just show you lordships.
Hardship, this issue was dealt in this.
The lordships have already.
That order was state of no. No. When this petition was disposed with recording of the categorical statements of state of UP, what was the date of this order?
This order is
dated 23/24. And now you're relying on which no objection by UP?
There is no objection by state of UP in the year 2021, and there is a no objection of state of Maharashtra of May 2020.
That was in 21. What prevented the state made a categorical statement?
That's why we went to High Court and said that there was page 17.
It's 20. Before this court, when you
have page 70.
Wait a minute.
Page 170. This is by additional chief secretary. In connection, Malas have it?
170.
Please, 170 in the SLP. I'm so sorry. This is by the additional chief secretaries, government of Pradesh.
Not so prison of Uttar Pradesh.
We have last line. It is said prisoner is transferred to the prison of Uttar Pradesh by the state of Maharashtra to serve the sentence given by the Honorable Court of Maharashtra State in Uttar Pradesh, then the state of Uttar Pradesh has no objection. Thereafter, Milos, they filed an affidavit. I'll just, Milos, point out that affidavit also.
No, but that, in that case, it was a transfer sought for by the state.
So what happens is that Milos, as per rules, as per prison rules.
Right, but that was a request made by state of Maharashtra to state of UP, not by the prisoner himself.
I made representation before both the states. It is as per the rules, Milos, I have to make representation before the sendee state as well as before the sender state.
Sender state, okay.
That's how it is, Milos, as per the prison manual.
Now this document was before this court when the petition was decided.
At that time, Milos.
Then.
But then Milos, the NOC of state of Maharashtra was not there, and then there was an additional affidavit.
But this court observed that when state of UP is not ready, there was nothing which would.
That is what. So Milos,
which would turn on state of Maharashtra's permission or no objection.
Yes, Milos.
It is one part of the order that state of Maharashtra, in spite of repeated notices, opportunity is not coming before this. It ends there. Then the court further observed that the state of UP is not ready to accept this prisoner.
So therefore, we went to Allahabad judicial review of the order. That is a review of Supreme Court order. Order by which the state of Maharashtra later come, Uttar Pradesh later come and said that no, it is not. We are not inclined to take him in. So we had to time before the state of Uttar Pradesh. Milos, for this purpose, that now we have both NOCs. Now I have the NOC from the state of Maharashtra, and in the Supreme Court when the matter was heard, the state of Maharashtra was sent about it.
On that submission, this order of the High Court is passed, which is impugned in this
SLP. And this SLP, Your Lordship, Milos, after considering everything, have stayed Milos the order of the High Court. This order has been stayed, Milos.
It is direction in impugned judgment.
Milos, after me, there is no direction.
No, it's only implement. You are representing state of Maharashtra.
Why
your response to this?
This application.
Why are you having any objection, Milos, for the reason that he is state of UP? He may oppose Milos, he will have another friend to oppose before your Lordship. So I do not know, Milos, why he just unnecessarily.
He is right. See, in this court, as the order, this document on which you place reliance was before this court.
The subsequent document was not there, which is the state of Maharashtra. State of Maharashtra later on, Milos, this document came to fore only and only, Milos, when I filed that.
State of Maharashtra document.
It is at page, Milos, 137. 137.
And the petitioner was convicted of a Tara case. The conviction was
confirmed by Supreme Court of natural life. Natural life, I've been studying for 33 years. I'm 72 years old.
Why you want to transfer from this to one prison to other prison?
Because because all my sisters and all my family members live in Varanasi, Uttar Pradesh. And I am, Milos, if I'm sent over there, Milos, I mean, the distance is about almost 1,300, 1,400 kilometers. It is not practical, Milos. I'm an unmarried person. I'm in custody from Milos 32, 33.
What is the state of Maharashtra?
The state of Maharashtra starts at page 140. And I will just go to the relevant paragraph.
Who is Amla Singh?
Because Amla Singh is my sister, my older sister.
Where is that in specific for that? Now, page 140 is only take appropriate action. Appropriate action be taken on application and the applicant shall be intimated.
I'm just not able to figure out because I was not ready. Some of may pass it what? Just one moment.
Otherwise, at least nothing to show that state of Maharashtra in clear words allowed the request. It is only.
I will show that. I will show that. What is the positive or issue?
Please, my lords, appear petitioner in this matter. My lords, this restoration application which is filed by us.
But now you have furnished the addresses after the stipulated time granted to you.
Please, my lords. Prior to that, we duly informed the petitioners. Petitioners are rural individuals, my lords. They were not aware and they were unable to get the details on time. They provided us the details only in the month of August. And it was subsequently filed by us. There's a letter filed by us and as well as applications, my lords, providing the requisite details. My lords, the letter is annexed as annexure number 4.
4.
Please, my lords. These are the fresh particulars for respondents number 4, 7, 8, 9, and 14. As well as, my lords, there was an application for deletion of the performer respondent number 13. An application for substitution of legal heirs of deceased respondent number 2. My lords, these have all been filed subsequently by us.
Then notice will have to be issued on this latest address provided. You fail to provide the address, now we are providing these addresses belatedly. Details of these respondents.
My lord, the address that we filed initially, service could not be situated on those. So we were directed to file fresh addresses. These were the fresh addresses which were obtained by the petitioners.
Yes, so you were supposed to provide those details within a stipulated period.
Please, my lords, that was an inadvertent error on the petitioner's side, my lords. They were unable to get the details.
Urgent counsel for the applicant, it is submitted that for non-curing of the defects, particularly failure to provide the fresh particulars in respect of respond number 3, 2, 9, and 14. The petition was dismissed in default. Subsequently, the matter was listed before the Honorable Chamber Judge on 9/10/23, and 4 weeks time was granted to take fresh steps with regards to the disease numbers 2 and 13, and also for filing fresh addresses of conserved respond number 3 to 19 and 14. In spite of an attempt being made by the council to seek the fresh addresses, there was no response, and the matter was relisted before the court on 14/2/24, and the Honorable Chamber Judge and the Honorable Court granted 6 weeks time as a last opportunity subsequently. The Council for Petitioner then issued various letters, reminders, and made telephonic calls there was no response, and the matter was again listed on 27/8/24. 1 week time was granted to comply with the office report. A conditional order was passed and 1 week time was granted. As the council failed to comply the office report within stipulated period, petition should dismiss. Subsequently, the Council for Petitioners made again attempts, and in response he could receive the fresh address of respondents 4, 7, 8, 9, and 14, and the same was supplied to the registry on 7/9/24. The council submits that though there is a delay in supplying the fresh addresses, the delay caused due to bona fide reasons, particularly the petitioners being rustic villagers and aware of the legal process, failed to provide necessary information to the council within stipulated time. As of now, the council further submits that as of now, there is a due compliance of the office report, though belatedly, and as the petitioner has raised substantial grounds in the petition, the application be allowed and the petition be restored by recalling the order dated 27/8/24. In view of the submissions of counsel, the application is allowed and petition is received.
Please, my lords, stay may also be granted. The court had initially.
The orally
The application is filed. It was filed yesterday since the office report came on the 9th.
application is there.
Please, my lord, sorry.
Council submits that a separate application for condonation of delay is filed, and as the delay caused in filing the application is due to bona fide reasons, delay be condoned.
Please, my lords, the court initially, while issuing notice in the SLP, had issued stay in favor. My lord, stay may be granted.
The matter will be listed before the court now. Let it accordingly application for restoration allowed. Let the petition be restored and be placed before court for further orders.
Was my point out, Milods, in 170 from?
Yes, yes.
At page 119, Milods. I'm so sorry, Milods, I couldn't. At page 119. Starts at page 119. Milods, at the end, the office has no objection for reciprocal transfer arrangement of convict prisoner who's already lodged in Uttar Pradesh jail of Fatehgarh Central Prison for undergoing his life imprisonment punishment there. This is, Milods, the report, and on the basis of this, Milods, the DG prisons at page 123 had passed, Milods, has issued the final NOC.
Lordship, there is no case pending in the state of UP. He was convicted Maharashtra state.
Right, but now the state of Maharashtra also submitting that they have no objection. The state of UP also communicates that they don't have any objection for this, and apart from all this, now notice is already issued by this court by granting stay to this order. So let him implement the state of Maharashtra as party and let the state of Maharashtra file its response.
He also grant to me time to file this line.
You are for state of UP, no? Yes. Okay, an application for implement, third council. Then a council submits that. Initially, a petition was filed before the state of UP. The same was
Allahabad High Court.
State of UP before Allahabad High Court, and same was dismissed, being agreed by the state judgment and order. The petitioner approached this court by filing special leave petition. Special leave petition was also dismissed. The council submits that at the relevant time.
No, I'm so sorry. It was a writ petition. I came in 32. I came in 32.
The petition was filed under Article 32 before this court, and same was dismissed. Subsequently, taking reports to Right to Information Act, the petitioner could obtain certain documents whereby state of Maharashtra in clear and unambiguous terms recorded its no objection for the transfer of this petitioner. As such, in the changed circumstance, the fresh petition is filed before this court, notice is issued.
I filed High Court. After that, I filed, I preferred, I'm sorry.
Consider that in changed circumstances, a petition was filed again before the High Court.
Arraying state of Maharashtra as party, respondent number 6.
And that was dismissed, being agreed by that order, the present special leave petition.
My lord.
By the order dated, and so notice is issued and the order is stayed by this court.
Please.
This being the position, the council thought it fit to, the petitioner thought it fit to file an application seeking implement of state of Maharashtra as necessary party.
As he was, as the state was missed due to my
we are already necessary party. Accordingly, issue notice.
State of Maharashtra. I'll serve them Dasti.
Notice to state of Maharashtra, the council appearing for state of UP also pray some time to file his response to the application.
Application was I don't understand was why he is objecting. Plus, my issue notice was to state of Maharashtra.
This is to state of Maharashtra returnable after 4 weeks. The council is permitted, the applicant petitioner is permitted to serve the state through the standing council apart from the usual mode of service. Council for state of UP also prays some time to file his response to the application.
Should I file below the amended memo party?
2 weeks. Let the parties come with their responses. Yes.
Lordship, 4-week time may be granted for surrendering.
You are exempted from surrendering and you are
Application has been filed for exemption, so I'm requesting for this one.
seeking exemption from surrendering.
Lordship. 4 weeks time.
What?
Actually, mother is very seriously ill and one younger daughter aged about 7 years needs admission and other things required.
What else?
So, my lord, I'm seeking exemption from surrendering. This is a case where I have all the 3 petitioners have been convicted under 302 read with 34. And my lord, the conviction has been based solely on there is a dying declaration. We are not mentioned in the dying declaration. There is PW3 who happens to be the last seen witness. He only says that he saw 5 people together. Please, my lord. My lord, my lord, this is a 1993 incident and High Court upholds the conviction in 2024. All throughout we have been on bail. We have a good, please, my lord. My lord, in the trial court, please, my lord, No, my lord, I have been. That is mentioned about 2 years we have been inside.
So against a life.
My lord, well, it's a good case because, my lord, there is a dying declaration. I'm not mentioned in the dying declaration. Then, my lord, PW3, I'm only convicted.
On that very evidence, conviction is recorded by both trial court, confirmed by the High Court.
I only show 3 paragraphs from the impugned judgment. That is, my lord, may kindly see that it is based on circumstantial.
That may be a good ground to consider your appeal, and even assuming that you will be successful in appeal.
Please,
right now, you are a person who was convicted by appreciating the evidence. This is 302 when life is lost.
My lord, in this case, there is no eyewitness. It is solely based on a dying declaration that I am not
So dying declaration, if it is believed, sufficient enough, no need to have a.
Just one point, my lord.
Yes.
The lordship may have para 14 on page 8. It's the impugned judgment.
Of the High Court confirming
Yes, my
the
lord.
trial
Yes,
court
my lord.
order.
My lord. Page 8, para 14. So, my lord, we have been convicted on the basis of dying declaration and the testimony of PW3 Santosh, who is he's supposedly the last seen witness. Now, my lord, he says that a day prior to Holi at about 8 a.m. he sees a motor vehicle which was stopped at so-and-so. A person alighted from that motor vehicle. That person has gone towards the house of so-and-so carrying so-and-so. He deposed that he does not know the relationship between so-and-so. Then he says when that person who had alighted from the motor vehicle was going towards Lucknow, then he was having bag in his hand. Thereafter, evening, one person came in a yellow vehicle. So
Okay, even assuming the last century is not proved, where is a dent in dying declaration?
Please, my lord may see very clearly. He says that he saw that
assuming the last century is not believed or not believable.
Please, my lord.
If there is a dying declaration, the person who is about to meet his death.
So my lord may see the dying declaration also. And my lord.
That can't be done in a minute or two.
Please, my lord. My lord, it is.
Both the courts found that the dying declaration trustworthy.
My lord, in this case, dying declaration, they have only said that on the basis of the testimony of PW3, who says that he saw 5 persons.
Madam, that's the last century.
Please, my lord.
So even keep the last century aside.
Yes, my lord.
Where doubt expressed by any court about the dying declaration?
My lord, please, my lord, that I bow down to your lordship. But my lord, there is glaring discrepancies in the testimonies and the basis the dying declaration. The dying declaration says
it is an independent material.
My lord, the
dying declaration, somebody who was subjected to an assault.
Yes, my lord.
Before his death, makes a statement that I was subjected to an assault by ABC. The way of my death is ABC, who were the offender, and if there is a specific reference to the act of the offenders, naming these offenders, and if both the courts find this particular evidence trustworthy, believable.
My lord, may kindly see the dying declaration. I've annexed it. It doesn't say it only. This incident took the dying declaration. It happened.
Appreciated by both the courts, madam.
Yes, my lord. Please, my lord.
Not for the first time this court is appreciating. Please show any of these courts raise any doubt about the dying declaration.
No, my lord. There has been no doubt with respect to the dying declaration. But my case is that I'm not mentioned. The deceased doesn't mention the names of the accused, of the convicts. Thereafter, I'm only convicted on the basis of testimony of PW3, who says he supposedly saw the deceased alight from a yellow car. It is in the dying declaration, the deceased is alighted from a bus.
You serve the state.
Please, my lord, I'll serve this.
Application for exemption from surrender.
Please, my lord.
Is returnable within 2 weeks. The applicant petitioner is permitted to serve the respondent state through the standing council or panel council of state of Madhya Pradesh, apart from the usual mode of service, and to place on record proof of the service.
I'm grateful.
So 8.
Please, Your Lordship, this is an application for exemption of surrendering listed Your Lordships. Lords, I wish to withdraw this because this was erroneously moved, as he is already out on bail. There was some confusion.
On the bail?
Out on bail, my lords, because the criminal appeal is pending. This was only an application that was rejected by the
public property was subjected.
There was a bus, which, as per the facts of the case, but there was a big crowd, so
But conviction is recorded.
Conviction is pending before the appeal is pending before the High Court.
Yes, but High Court confirmed that conviction. Now you are before this court.
I only wish to
challenging
withdraw
those
this.
orders.
I wish to withdraw this application. May it may be listed before the Honorable.
Okay, the council on instructions pray for withdrawal of the application. Against a conviction being recorded for offences committed under 325, 304.
My lord, there I'm not convicted.
There-
Conviction is under 304 part 2, admittedly, my lord. And that, my lord, the
Let us see the order of the trial court.
Please. Your lordship wish to see the judgment of the trial court?
Yes.
That's, my lord, at page 157.
57.
And my lords may straight away come. It's a case of a single blow.
234. Single blow weapon used.
Lathis are attributed and there's supposed to
Lathi.
be 7, my lord.
Citus.
My lord, on the head. But there's a single blow, my lord. So there's supposed to be 7, my lord, assailants. And yet they come away with a single blow, which leads one to question, my lord, the veracity of the. And my lord may just see.
Where is the medical certificate?
Lord, the doctor's evidence is on the record, but if one moment, if I may just show your lordship at page 155, end of 155 of my lord's
What is
harder.
it?
The last two paragraphs, 3042, my lord, is upheld. It has come in evidence that the specific lathi blow has been given by.
155.
Yes, my lord. By Asit and the remaining, my lord.
Death was caused due to head injury, which was
Yes.
antemortem, homicidal. There is cogent evidence pointing the guilt of the accused person.
Yes, my lord.
So preponderance of probabilities does not attract. Minor contradiction and some loopholes in prosecution will not result in creeping doubt. No doubt in the manner of the involvement of the accused. No doubt. There appears no doubt in the matter of involvement of the accused person.
Very well, my lord. But my lord, I'm just
Yes,
showing, my
found
lord,
that
the 325.
lathi blow has been given by Asit. So is liable for 30 part 2. So for other, the same. The command of Sri Kumar. They all are very liable for 304 part 2, 34. So you admit your presence. You were on the spot along with somebody that is the main assailant, facilitating him.
My lord, my submission is one.
The case of the prosecution.
That's the case of the
The
prosecution.
case of the
That's
prosecution that.
As far as the appellant, my lord, the petitioner number 1 before your lordships is concerned, there was a prayer of juvenility also which was raised. That, my lord, appears not to have been dealt with or allowed by the
Not serious or not seriously raised.
My lord, it's raised in the appeal also. I'll just show your lordships. It's raised, my lord, if my lord
But
just see the.
then somebody loses life against that, you are not even 2 weeks behind bars.
My lord, it's about 6 weeks, my lord. I'm not disputing the period, but it
To
is.
serve the state.
As your lordships. As your lordships.
Normally, if
please.
they, otherwise, if they
My
were
lord, I
giving a
only
cert person saved, life is saved, then one can consider.
So
His
please,
life is
my lord,
lost.
I'll only pray for this aspect, the High Court, my lord,
We'll make
had
it
granted-
returnable early in 2 weeks. You serve this.
My lord, I'll have to, in that case, surrender, my lord, because the 1 month time was granted to me, and my lord, the SLP was filed within that time, my lord, but unfortunately it was not listed before your lordships before today. So I'll only pray, my lord, may give me 2 weeks, my lord, make it returnable in 2 weeks, but let the exemption
2
be.
weeks exempted from surrender till the next date only.
I'm most obliged. I'm most obliged. My lord may permit me to serve by all modes. As far all the standing
Permitted to serve the respondent state of West Bengal to the standing council or panel council apart from usual mode of service.
I'm most
based on record proof of service.
May I please your lordships? Whereas I'm seeking 2 weeks time to do the needful as per the office report.
What happened? Council has not spare copy notice. Service not complete on sole respondent exempted from. Thereafter, you surrender. Applicant was exempted from surrendering till 9/4/25.
Please, my lord, subject to condition that the appeal be listed before the High Court. When the matter was listed, it could not be taken up for hearing, my lords. As per 24/3/2025.
Let us see the order of granting you exemption from surrender.
Please, my lords, that is 24/3.
24/3. This court only.
Please, my lords, your lordships had passed.
This appeal surrender until appeal be listed at court of which you will be. When you saw the council for the state,
My lords, we had e-served the council for the state. On
where is copy of that mail?
I have the copy, my lords, with me.
Why it was not placed on record? You were permitted to do that. When you saw, let us see.
Para 3 of the office report, my lords, it also states that we have filed Para 3 of the office report, my lords. Just
Madam, you were permitted to serve by order dated 24/3/25. You have issued a communication email on April 8/25. So, normally short orders are passed. A detailed order is passed by this court noting the approach of the applicant and the counsel of the applicant not assisting the court, with a rider that you shall surrender to the court on so and so date. You are supposed to inform the counsel on the, so even assuming that a day or two couple of days, but now you have informed the counsel after a month practically. So how the council will file and submit his report? You will have to take instructions from the state.
So, my lords, we had e-served them. My lords may grant me a week's time. I will file the spare copies and do the needful as per the office report. In the meanwhile, my lords, I had sought instructions from my client that when the matter was listed before the High Court on 5th of April, as passed by your lordships, what had happened, as per my instructions, the matter could not be taken up for hearing due to the due to heavy board, my lords.
Sorry?
Due to heavy board, the matter could not be taken up for hearing.
Then you surrender to the prison authorities.
My lords may grant me a week's time. Last
No, you
My lord,
had sufficient time.
I had served them, my lords. May grant me a week's time. Only a week's time.
No, you are enjoying this liberty.
Absolutely no, my lords. Absolutely no, my lords. We are complying with your lordship's orders as well.
Firstly, this court records that the opportunity was granted to the council. The council was not ready to hearing the appeal. Adjournments were sought for. The High Court was pleased to revoke the earlier order and sought the presence of the petitioner accused. You are taking the court for right. Yes. 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 Yes.
We had e-served
You were supposed to at least inform the state council when the order was passed on 24/3. One can understand a day or a couple of days collecting the order, informing. You have informed the state by your communication dated 8 April. You took your leisure time. And resultantly, applicant is also taking his leisure time. This is nothing but the misusing the liberty granted by court and taking the court for right. The court is seriously objecting the approach of the petitioner and the council who is not assisting the court for disposal of the appeal. When the matter was listed before the court was pleased to observe that there is no assistance from the council and the matter is sought to be adjourned on one ground or the other. This led the court to revoke the earlier order, prompted the court to revoke the earlier order granting protection to you. Now, in spite of the order passed by this court on 24/3, the communication is forwarded to the State Council on 8/4/25. You surrender to the authorities.
My lords may grant.
Let your appeal be heard by the court. You take adjournments.
We may have the impugned order for a moment.
Sorry?
My lords had passed the detailed order. I'm grateful for that. I'm only requesting a week's time, my
The
lords.
intention of that, at least you will consider this order seriously.
Directly I had served, my lord. Directly I had served them. Thereafter, I e-served them also. However, only this
There was no prohibition to you serve by email immediately after the order was passed. There was no need to wait at least 2 weeks to communicate the State Council. If you could have served him, forwarded him e-communication, he could have obtained the report of the state and could have placed before this court.
Grant me last opportunity, a week's time, my lords. I'm not seeking any more further opportunity apart. Only a week's time, my lords.
Council submits that by way of order dated 24/3/25, the petitioner was committed to serve the notice to the state through the learned standing council along with usual mode of service. The applicant was exempted from surrendering till 9/4/25. The council submits that the state council is served by way of an email dated 8th of April 25. The council submits that though there is some delay in forwarding email to the state council, the delay is due to inadvertently there is a delay in forwarding the email and considering this bona fide mistake, the delay be condoned. And this court may consider this delay on account of an inadvertent error could the council then pray for a week's time to submit a fresh report pursuant to the order of this court dated 24/3/25. Fresh report, submit fresh report before this court pursuant to the order dated 24/3/25. The council further pray for council then pray for further exemption from surrendering at the request of the council 1 week time granted to submit a report pursuant to the order dated 24/3 and the exemption from surrender is extended by a week, that is till April 22nd. Let the report be submitted by the council for applicant petitioner on or before 21st of April. This is not proper, madam. The applicant is taking the course for right.
Waiting for one last opportunity, my lord, to serve the respond number 7, my lord.
1 7. What? Okay, you're seeking 1 week, 2 weeks time.
2 weeks time.
At the request of
Deeply.
2 weeks time.
Yeah, please. Lord, my substitution of LRs, Lord, there's some defects, Lord.
Notice, yes.
I'm seeking 4 weeks time to cure the.
At the request of the council, 4 weeks time granted to cure the defects.
Oblige.
Not cure the defects. 1713. Parcel. 1713. 1714 also defects are not
My lords,
cured.
I am appearing in 1713, my lords. For the petitioner, my lords, 4 weeks time be given to file to cure the defects, my lords, to file the senior
1713.
certificate.
You are in 1713.
Yes, I am in 1713, my lords.
Taking time of how much?
My lords, 4 to 6 weeks to file senior certificate.
Granted as a last chance at the request of the council to take steps. 1714, yes, Mr. Council.
4 weeks time may be granted.
4 weeks time granted as a last chance. Steps not taken. Yes, madam, you are appearing in 1715. Is in 1715. Madam, you are not audible.
My lords, am I audible now?
Right now, yes, now you're
My
audible.
lords, I apologize, my lords. We were to cure defects in curative, but due to some communication error, we were not given we did not get an access to the list of defects. We have recently just gotten it corrected. We
2 weeks?
cure the defects.
2
Do
weeks?
the needful.
Yes.
4 weeks. 4 weeks if possible, my lords.
How much time you want?
4 weeks, my lords. 4 weeks.
4 weeks as a last chance to cure the defects.
Grateful, my lords.
Lordship, I am also praying for 4 weeks time for curing defects.
Defective. Petition is defective. Okay. 4 weeks time to take steps. Well, to take steps. 1717. Yes, Mr. Counsel. Counsel for petitioner failed to take steps. 722. 1717. Pass. 1718. None for the applicant petitioner list after 2 weeks. For direction, this is incomplete. None for the petitioner, 2 weeks. One 1719. 2 weeks. 1719. Notice is incomplete. Yes, 1719.1. None. List after 2 weeks. 1719.2. Same thing. List after 2 weeks.
My lord, I am seeking 4 weeks time to comply with the necessary direction.
Yes, 4 weeks time granted at the request of the council as a last chance.
Obliging.
On for respondent, petitioner, he has your lordships granted.
Petitioner has to take certain steps, has not filed IA substitution. Let petitioner take steps, list up, yes.
Lordship, I am appearing on behalf of the petitioner in 1722.
1722, yes, certain steps are to be taken by you.
My lord, I have already taken steps. I have already filed an affidavit of service on 25th February 2025 with regard to 3 respondents. There's one IA that I have filed. There is IA number 286447. This is application for deletion of names of respondent number 14 to 16, since they are official respondent, and the dispute is between the private parties. So I would like your lordship to kindly go through that application and allow
But then
the
there is other objection raised by the office.
for other objection, my lord.
Application for substitution.
Substitution of respondent number 4. Yes, my lord. My learned friend has already filed a wakalatnama, so my lord has ample power to dispense with this service to the legal heirs of respondent number 4. My learned friend standing over there has already filed a wakalatnama on behalf of respondent number 4.
Insofar as the objection for not filing IA for substitution on behalf of respondent number 4, it is submitted by the council for the petitioner. That respondent number 4 is already being represented by the council, and our wakalatnama is filed by respondent number 4. That Advocate Mr. Yadav confirms this statement. In view of this fact, the objection is waived. Now your application for
deletion of names of respondent number 14 to 16, my lord. They are official respondent.
They are performer respondent. They are holding.
If is claimed against them,
there is nothing against them, no claim. They are official respondent, performer respondent in a way.
Just a minute. Go through that and then. 7. But these of the office, the respondent of 14 to 16, they are the officers.
They are no officer,
Any
but they
order
have.
of, any order of any of these officers was under
No.
challenge.
No, Your Lordship, no. No, they have not been appeared, they have not appeared in the High Court as well as before this court. It's a private dispute, my lord.
Orders are part of ledger, part of brief.
The unconscious submits that the respondent number 14 to 16 are the officials, namely Deputy Director of Consolidation, Settlement Officer Consolidation and Consolidation Officer, Basti, Uttar Pradesh. The council further submits that the dispute is between the private parties, namely the petitioners and respondent number 1 to 13. The council further submits that neither any order passed by these officers is under challenge, nor any relief is claimed against these respondents, and the respondents were added as pro forma respondents to the petition. As such, the council prayed for deletion of these respondents number 14 to 16 from the array of parties, that is respondents, accepting the statement of the learned council on the wish and risk, at the risk of the applicant petitioner, the application is allowed in terms of prayer. Consequent steps be taken within 2 weeks.
My lord, one more submission, my lord. In the last order of the learned registrar, it says that I was supposed to file proof of service to respondent number 5.1, 9.1 and respondent number 12. I have already filed that, so kindly record that also. Affidavit of service.
That is not the objection. Not there.
All right. I'm deeply obliged, my lord.
After 2 weeks, matter will be placed before Honorable Court, Your Lordship, as per rule. Otherwise, they have taken interim relief and till matter is going to.
If the service is complete on respondents and if there is no other impediment, the matter will be listed before the court for further orders.
I'm deeply obliged, my lord.
Of course. The rest of the matter will continue.
1723.
Continue post lunch.
I mean 1726.
We'll continue post lunch.
I'm only withdrawing my SLP.
Withdrawing your SLP.
Please. Item number 1726. I had already filed an application for withdrawal of SLP, which is listing today. Obliged.
On instructions.
723 could be taken up as.
Just a minute. The council submits that 1726. Just a moment. Let us just see your applications.
That application, the detail of application is mentioned in the office report also.
Withdrawal. The council submits that the petitioner is not desirous of prosecuting the petition and accordingly the present application is filed. In view of the submission of the council, the application is allowed in terms of the prayer, the petition accordingly is dismissed as withdrawn.
Your Lordships, in 1723, the petitioner is also there, and for respondents, if it could be taken up at post lunch, I have little difficulty.
It's 1723. What happened? Order was passed there, no? None present. So it was directed only to be leased after 2 weeks.
No, I'm for respondents number.
So wait.
Item number 1728.
2, 3. So post lunch will take up your matter. We have reached up to 1722. Your matter is 1723. We'll continue. 1728. Wait. Yeah. Coming after lunch.
Just on the base, all the application.
You mention it.
Hello.
Your Lordships, and for respondent I'm Gadi Khanna for respondent 19, 20, 21 and 22 Raj Bahadur.
Lordships, I'm for the intervener. There are two applications, IA 143128 and 143129. Intervention and directions. The main matter has been referred to the Constitution bench. It's regarding inter se seniority between direct recruits and promotees. There was judgment of N.R. Parmar, which said it should be from the vacancy year, and then there was Megha Chandra. And the recent decision of December 22, a three-judge bench of this court has referred the matter to a Constitution bench. Lordships, we have filed an intervention because we were original petitioners in the first judgment Parmar. The request is Lordships may allow this intervention so that whenever the Constitution bench is constituted, we can also be heard there.
Yes. For Union of India. Yes. No objections.
Also, my lord, I am in IA number 144682, a similar intervention like my learned friend has. We are also on the similar footing and we are affected by the outcome of the reference.
In the Parmar judgment, Lordships, in the Parmar judgment, the judgment before this. I'm obliged. That was an application for directions, Lordships, but we had filed when the matter was before the three-judge bench. So we had filed for intervention and directions. I'm obliged.
My lords, even my intervention application.
Both applications.
1446.
Both
Very
applications, sir.
Very well.
My appearance may be recorded, Your Lordships.
Yes.
Your Lordship, in item 1724, I am appearing for the petitioner, Your Lordship.
Applications are defective.
Yes, Your Lordship, I apologize, Your Lordship. I could not remove the defect, Your Lordship. Please allow me 2 weeks' time, Your Lordship, to
Time granted.
cure the defect.
At the request of the council.
Please,
to
my
cure
lords.
the
Thank you, my
defect.
lords.
Clear me over next year.
Two six is also for withdrawn. That was mentioned 1726 before lunch. It's allowed. 1727.
Please, my lords, my application IA number 87380, seeking deletion of pro forma respondents 18 and 19 is for your lordship. My lords, they are pro forma parties.
No relief was claimed against them?
Even before the High Court, they were pro forma parties, my lords. Lords may have page 153 of the memo of parties, my lords.
The counsel for the applicant. The applicant pray for deletion of respondents number 18 and 19 from the array of parties respondents. The submission is the legal counsel submits that respondent number 18 and 19 are pro forma respondents. No relief was claimed against them. In view of the submission of legal counsel and admission risk of the applicant petitioner, the application is allowed in terms of prayer. Consequent steps be taken within 2 weeks.
Please, my lords, there's another IA 26428. Because that is for dispensing with service for the same respondent. My lord, I'll withdraw that application.
Allowed to withdraw, dispose as withdrawn.
Well, if I may mention item 1725.1. It was not called.
It was called out.
No, unless it was not called out, unless I'm logged in since post lunch. Unless it's an application for withdrawal of the SLP.
Withdrawal of the
I'm praying for a
SLP.
liberty to. Yes, Malas. In 1725.1. Plus 1725 is the main lead matter, which has been directed to be listed before the Honorable Court. And Malas 1725.1 is the matter which was tagged to the lead matter. I'm seeking a permission to withdraw the 1725.1. Murthy Devi versus State of Haryana.
Yes.
And well as the limited relief that I'm seeking, that I may be given liberty to approach the Honorable High Court for seeking the said relief.
No, petition is filed. The petition was filed challenging the order of the High Court. In High Court.
Yes, Malas, exactly what had happened, Malas, Malas, before the High Court, no relief for the release of the land was made. There was no prayer clause in the writ petition filed before the Honorable High Court that the land be released in terms of the stated policy of the state of Haryana. Unfortunately, the previous AOR, he filed the SLP and got it tagged along with the Vikas and others matter, the 1725, wherein the relief sought and the grounds are completely different. Yes, Malas?
Where is the High Court order in your matter, this Murthy Devi SLP? Which was the order impugned in the petition?
Malas, the order impugned in the petition is at page 125 of the SLP paper book. It's 7th August 2024 order, Malas.
What is that? Page 6. Page 1.
Plus page 6.
This was the petition filed before the Punjab Haryana High Court.
Yes, Malas.
This was
so
petition.
The petition came to this.
Your petitioner number 10, Murthy Devi.
Yes, Malas.
Now an order passed in this petition is subject matter of the SLP.
Yes, Malas. Malas, my humble submission is, Malas, what had happened before the High Court was that in this particular writ petition, the Section 4 and Section 6 proceedings under the previous Land Acquisition Act of 1894 were challenged. There was no prayer clause. Let's may come to these SLP, the writ petition as came to be filed before the Honorable High Court. That would be at page, that's annexure. It's page 75 onwards, annexure P9 of the paper book.
Wait a minute. No, this petition filed by you and other petitioner, that is nursing and others, that was dismissed in view of an order passed in 13549.
Yes, Malas, it came to be dismissed.
So what
Now,
was
Malas, what had happened?
What were the prayers in this petition?
Malas, the prayers in these
8633. Where's the copy of that petition?
Malas, it's annexure P9.
Page?
Annexure P9 at page 75 of the paper book. And Malas, the prayer clause would be at page 145. Malas, the prayer clause at page 145 onwards, and Malas, there is no prayer for the release of the land in view of the stated policy of the government, because Malas, residential structures are constructed on my land prior to the issuance of Section 4 notification, Malas. And that relief was never claimed. Page 145 to 147
Wait a minute.
Yes, Malas.
So notice under Section 4, Election Act was
Yes.
under challenge.
Yes, Malas, the notification Section 4.
Intention was to acquire the lands.
Yes, Malas.
Who were the landowners as per the record?
Yes, Malas.
You were the landowners or encroachers on the land?
Yes, Malas. Malas, we are the landowners, Malas.
What was your status? Whether you were landowners or the encroachers?
No, Malas, we are the landowners, Malas. We are the landowners admitted by the state. There is no dispute for that.
So you challenge the notice of seeking acquisition of the land.
Yes, Malas.
Now you are, by another way, you are again seeking releasing of land from acquisition.
No, Malas, what Malas, exactly, Malas, we had challenged this.
Ultimately, you are challenging the action of the state government.
Yes, Malas.
Name may be different. Intention of state was to acquire the land. You are the landowner. You are opposing that notice or intention of the government. That
Yes, Malas.
petition was dismissed.
Yes, Malas.
That order is under challenge in SLP.
Yes,
Now,
Malas.
seeking withdrawal, if you are seeking simply withdrawal, no difficulty. But again, seeking permission to challenge, to go before the High Court under the name and prayer to release the land, is the same relief, only.
Malas, if I may just give me, Malas, I bow down to that. I just need 2 minutes, Malas. Malas, what we had challenged is Section 4, Section 6 notification, saying that the act.
No, therefore, if you are simply seeking withdrawal, it's okay. Otherwise, this is only by changing the name you are seeking permission to raise the same issue.
No, Malas, not the same issue. Malas, what I am seeking is the release of the land in terms of the policy of the state. There is a policy by the state.
When the policy was framed?
Well, the policy is the state policy of 2008, 2010, and later on amended subsequently
When
also.
the petition was filed before High Court?
My petition before the High Court was filed before the award was passed.
When?
In 2020 it was filed.
So when you file petition, state policy was in operation.
Plus the policy was in operation, but plus I could not have asked for release.
You could have raised this point itself in the petition that if there is a state policy, there was no reason to acquire the land, and my land could have been released by the state following its own policy.
Malas, I bow down to that. Malas, the issue is that I could not have asked for that particular relief back then. I'm telling you, Malas, there is a policy by which say
Then this will be a chance petition. What you could not seek in earlier writ petition, now just by change of the name on a ground that you are seeking another prayer, but the result would be the same.
Malas, my issue is Malas, what had happened, Malas, in the SLP, we cannot ask for a relief which was never prayed before the Honorable High Court.
Nobody prevented you. Nobody prevented
no ground.
Take support of the state policy.
Malas, that's exactly, Malas, if
as an additional ground,
Malas, my issue is very simple, Malas.
You thought it fit and chose not to raise that ground. That was your decision.
Malas, this SLP came to be filed by the previous AOR. He took all the grounds which were never pleaded before the High Court, a relief which was never sought before the High Court, and that has been claimed in this particular SLP. Now, Malas, the moment I go into the merits of the case, initially I'll have to cross the technical hurdle that the issue which was never raised before.
That's right. Therefore, only to avoid that query which would be raised or by way of a counter would be raised by the other side. Now you are seeking withdrawal and then at the same time permission to go before the High Court raising this issue.
Only the issue are the release of the land in terms of the policy of the state, Malas.
Ultimately, for the very relief, you are seeking release of your land. Right?
Malas, but when I challenged before the High Court, I had challenged the.
What is your ultimate? To protect your land. To protect
yes,
your land.
Malas may hear me.
And because you are in apprehension that state government is in the process of acquiring the land.
Malas, my submission is that the state has already acquired the land. When I approached the High Court in 2020, I challenged the Section 4, the land acquisition proceedings. No award came to be filed till the time I challenged them. I only said that the Section 4 and Section 6 proceedings are not in conformity with the law. That is the Land Acquisition Act. That was the limited relief I claimed before the High Court. Nonetheless, during the pendency of it, award came to be passed. The land was acquired in 2022, post the filing of my writ petition. Nonetheless, the High Court has only dealt with the issue for the legality, whether the entire proceedings of the entire land. We are landowners of only specific portions of land over which residential structure has been constructed prior to the initiation of the land acquisition proceedings. And there's a valid ground in the respondent state's policy that if there is a residential structure prior to the issuance of Section 4 notification, when the land acquisition proceeding starts, we are entitled to seek release of the land. But the land was acquired only in 2022, post the filing of my writ petition. And the issue is that I wanted to be be very humble and be very upfront with this honorable court. That is the reason, because the previous AOR, he took all the grounds which were never pleaded, sought the relief of release of the land, which was never prayed in the writ petition. Plus, that's the reason that I have come in this particular application saying that I should be given liberty to withdraw this SLP and to approach the Honorable High Court to seek the relief, which I am legally entitled as per the respondent state's policy to seek. And this issue, the challenge in the writ petition was for the entire legality of the proceedings. If my writ petition would have succeeded, the entire land acquisition proceedings would have been quashed. Right now, I'm seeking that only few of the landowners who have residential structure constructed on their land, only their specific khasra numbers to be released. The entire award will not be challenged or will not suffer any legal issue from our side. Only for the release of certain portions of land over whichever our own house is built prior to the issuance of the acquisition proceedings. That is the only humble request.
Now, out of these 17 petitioners, how many petitioners were with High Court?
Plus the petitioners who have come before in this particular SLP are they are only, let's may see the meme of parties, it's at page 22 onwards. There are only 4 petitioners. It is the relief is the liberty is being sought for only those 4 petitioners who have their residential structure, their own house in which they are living, constructed on the land before the land acquisition proceedings even started. And the respondent's state policy is that this particular land should be released. It's the liberty is being sought only by these particular 4 petitioners, and the
petition was filed, you join hands with Narsingh, Ranbir and others, right?
Yes, Malaj. Yes, Malaj.
When you approach this court, you were only 4 challenging the order, making the other petitioners respondents.
Yes, former respondents, Malaj. Malaj, for the reason because Malaj, only these 4 petitioners have a residential structure constructed on their land prior to the issuance of the land acquisition proceedings, the section 4 notification, Malaj. So only these 4 petitioners are seeking the liberty to approach the Honorable High Court to seek the relief, which they are legally entitled as per the policy of the government.
Where is that statement in your petition that your case is little bit different from other petitioners? Show that in the petition filed before the High Court along with Narsingh.
Let's come to page 32.
8633. Where is the copy of this petition?
Which page?
You just refer to the prayers at page 145.
Yes, Malaj.
The petition starts at page.
Malaj, it starts at page 75. Connection P9.
Page 75 and then it's page 80.
Nonetheless, the challenge before the High Court that all the landowners went, these particular set of landowners.
Therefore, show the statement in petition that your case differs from other petitioners. The other petitioners challenge the notification, they are the landowners, whereas you landowners have constructed your premises, residence over the land.
Malas, I've stated so in my SLP in the ground, Malas, page 30.
Please show that statement in your petition before the High Court.
Nonetheless, in the petition before the High Court, the issue, the relief, or release of the land as per the policy of the government was never sought. There was no prayer. I just showed from page 145 onward, there was never a prayer.
Why this factual position was not there in the petition? That you have already constructed residence over the land.
Plus, it's an admitted position by the state also that there is, I have filed section 5A objection.
Stop making that statement in the petition, state government admitted that position.
What had happened was section 4 notification comes in, then landowners have an opportunity by way of section 5A objections.
If this is your case that you are now only trying to protect your land where the construction is already standing.
Yes, Malaj.
Nobody prevented you to make that position, factual position clear when you approached the High Court. There was nothing so as to preventing you from making that statement, which was an important factor which could have been in the consideration of petition also. If that was not done by you when you approached High Court, this was a factual aspect that you have constructed residences over the land.
Yes.
No, sir. Please tell us what prevented you to make that statement before High Court, making a different case that though you are the petitioner number 1 to 7, 8 are having a different position insofar their land there is no construction. Insofar as petitioner number 10, Murthy Devi and other petitioner have construction over the land.
Malaj, these are part of my 5A objections which I filed before the High Court. Plus, I'd filed, and as a part of annexures, I'd filed the 5A objections, and it's recorded in my 5A objections.
Show that statement in your petition before the High Court that this is a factual position. We have constructed our residences over the land.
Let's say may come to page 93. I have attached the section 5A objections, and those 5 exemptions are there. Annexure P11 to EP15. In those 5A objections is recorded.
Let us see copy of your objection. Yes, that statement is made at page 92. Petitioner raised their objection within time stipulated under 5A of Land Acquisition Act to the notification. Sought exemption of the land from acquisition. Let us see that objection filed before the land acquisition officer. Well, the copy of that objection. P11 to P15.
Unfortunately, I was muted. Made the 5-year objections are at page annexure P7, page 69 onwards.
Okay.
Annexure P7,
A.
Para 1 at page 70 details the construction.
These are the independent objections submitted.
Yes, of these particular landowners, the 4 petitioners before this.
Where is the objection by these petitioners, Murti Devi, Rajendra, and Mukesh Kumar and Malchand?
May come to page 73. It is signed by Lekram Malchand and son of also and so on. This is a common file. These khasra numbers mentioned herein are of these 4 petitioners. And page 71, para 3, details that the applicant's house made in the interiors of rectangle number so and so.
This was a joint application. Where do we find that joint application by these 4?
The khasra numbers are detailed there in In the para 1, khasra numbers and everything is detailed, the description of the land. And para 3 details, the construction being made.
Please come to para 3, read that, where there is a reference of houses or house.
The applicant's house made in interiors of rectangle number so and so is approximately 20 years old, and rectangle number so and so is 12-year-olds. Guava or orchid in rectangle number so and so is 10 to 12 years old. It details the description of the residential structure being constructed thereon.
Yes, of one applicant.
No, it details the entire khasra numbers and all those are detailed.
At least para 3 refers to only one house by the applicant. It's not there that the other applicants also are having their houses constructed. Otherwise, it could have
I'm saying even if there is a 5-year objection, that the law is, if I had filed 5-year objections wherein I have detailed all these things, if I have filed all these objections and there are detailed in my 5-year objection, only then my land would be released, my lords, not otherwise. So, my lords, I'm only seeking, my lords, a liberty to pray for this particular relief. My lords, but the issue is, if I withdraw this
Then we
SLP,
can only say that to avail the remedies as available under law.
yes, my lords, as available under law, my lords.
Counsel for the.
But my lords, I should be given that liberty to approach the High Court for this particular relief as available under law. If the policy permits me to have this relief,
We will only say that remedy as available under law, and as we have not, this court had no, not
plus
applied
the
anything
well, the
about-
word liberty has to be mentioned because if I go to the High Court now, they will say because you had challenged it in by way of SLP, you cannot come here. That would be the only issue, Malas. That liberty should be given to me, and the liberty should be as available under law, Malas. I have no objection to that. But the liberty word needs to be mentioned, Malas. That's my humble submission.
Further on counsel for the applicant petitioners. The counsel for the applicant. Pray for withdrawal of the petition with liberty to avail appropriate remedy under law, including approaching the Punjab and Haryana High Court for seeking release of their land in question from acquisition proceedings. Admittedly, the petitioners namely Murthy Devi, Rajendra Singh, Mukesh Kumar and Malchand have approached Punjab and Haryana High Court by filing civil writ petition 8633 of 2020 along with other petitioners, namely nursing and others. The petitions, the said writ petition 8633 of 21 was dismissed by the order dated 7/8/24 and the order reads thus. Court page 5. Petition is dismissed for reasons. See detailed order of even dated passing 13549 of 21 nursing and others versus state of Haryana and others. The legal counsel for the applicant petitioner submits that in the said writ petition, page 633 of 21. Challenge was raised to notification number page 145. So and so dated 10 January 21, issued under section 4 of Land Acquisition Act of 1894. As well, notices dated 8/6/20 calling upon the petitioner to hear their objections under section 5A of the Repealed Land Acquisition Act of 1894. The learned counsel for the submission. When the petition was filed, the land acquisition, the process of land acquisition was at initial stage, and subsequent to the decision of writ petition, the process was complete by declaration of the award.
Plus, the award was declared on August 2022.
During pendency of the petition or post decision?
Plus, during pendency of the petition, the award came to be passed.
During pendency of the petition, the process was complete by declaration of the award. Learned counsel submits it. While filing the special petition before this court, the advocate on record read certain grounds in the special leave petition, taking recourse to state policy.
Yes, Miller, state policy.
State policy reflected under certain notifications. The learned counsel for the submits that these very grounds were not raised in the writ petition.
Yes, Miller. And Miller, the relief of release of land was never sought in the writ petition.
And neither the grounds were raised in the petition filed before the High Court, nor any relief regarding the release of the land was prayed before the High Court.
Yes, please.
Under these circumstances, the petitioner is permitted to withdraw the present SLP with the liberty to avail appropriate remedies, including approaching the High Court by raising the necessary grounds and appropriate prayers, and by making appropriate prayers. In view of the submission of the counsel, the application is allowed in terms of the prayer and it's allowed in terms of prayer. This court, it is made clear that a reference is made in this order to the submissions of learned counsel, and no opinion is expressed on merits of this submission of the learned counsel.
Deeply obliged, Manoj. Very deeply obliged.
So I'm appearing on behalf of the respondent number 1 and 2, the applicant of the present application. Lordship, I made a request before the lunch that we wish to withdraw the present application. We are not pressing the same.
Withdrawing the application.
Yes, Lordship.
The request of the funds.
With the liberty, Lordship, to avail any remedy as per the law.
You sought clarification of the order, then what remedy?
Lordship, a fresh cause of action has been arisen because we have submitted we have already submitted a revised map with the GDA, the respondent number 3 of the main matter. And even as per the previous orders dated 5/2017, the annexure A1, so clearly stating that map had to be submitted.
So you were seeking direction by way of this application to whom?
To the respondent number 3, Lordship.
So by seeking withdrawal, what other remedy you are, what other procedure like to file? Your prayer in the application clarify the order dated 5/5/2017 passed by this court. Now this clarification is sought for after how many years? After 6 years, 7 years. And your other prayer is direct GDA to take decision so and so without insisting applicant for obtaining NOC. Simply withdrawal is right. What liberty? What liberty you are praying then?
If uninfluenced by any liberty approaches, if
No, it will have the order of this court will have an influence. Order is passed to have an influence over the authority. Not yes, if the authority by rules insists for no objection, the other authority, subordinate authority, would ask for no objection. How by seeking liberty that can be waived off?
if you see the order dated 5/7/2017 at page number 20, it was submitted specifically to the GDA, the respondent number 3, that the respondent number 1 and 2 shall submit a new plan to the GDA within 2 weeks, and hence the said authority shall consider the same and pass appropriate actions within 3 weeks from thereafter. We have submitted a new map after that, so
after 6 years.
We had already submitted it, and after that, the
The
GDA.
court permitted it to submit the map as and when you wish.
We had already submitted, then a revised map was also submitted recently in the month.
The stipulated period to submit the plan was 2 weeks after the order, not 6 years.
Map was already submitted beforehand as well, and then also after that, we had also submitted another revised map as well, which was another map which was submitted on 15/1/2025.
15/1/25, 6 years.
Much of a map was already submitted beforehand, and then the GDA raised an objection to claim the NOC from the.
If pursuant to the order of this court, your map was submitted within 2 weeks, tell us that date of that submission of the map. If it is 25, then this. This order was passed on May 5th, 2017. Right. The issue was in respect of some high-rise building in city of Ghaziabad. That map was submitted at that time. The court permitted the authority or the petitioner to submit a fresh map within 2 weeks. New plan to the Ghaziabad Development Authority within 2 weeks, and the authority shall consider the same and pass appropriate directions within 3 weeks thereafter. You tell us that within 2 weeks such fresh map was submitted.
It has not been annexed, but that map was submitted. Now it has been another revised map. The main objection of the GDA was to claim NOC from the adjoining part. Then the another map was submitted.
No,
The
please.
plan is not sanctioned.
Please show that as per the order of this court dated May 5th, 2017, the map was submitted within 2 weeks. And then there was a decision by the authority within 3 weeks, as directed by this court. Otherwise, neither you nor the authority can take their own sweet will to file the application and decide it.
Of the application.
Review petition was filed, which was dismissed.
Review petition was filed by the state lordship. Not by us. Even thereafter, an MA was filed in the year 2017, wherein this Honorable Court also ordered that the order dated 5/5/2017 should be guided in letter and spirit.
So
Your
show
Honor.
that within 2 weeks the application was filed, authority decided your application and directed you to file a fresh map. And accordingly, you file a fresh map in 25 January 25.
Was no map, no plan was ever sanctioned after that. Even when we had filed an MA in the year 2017 on wherein this Honorable Court in the Annexure C
When this court directed you to submit a new plan, meaning thereby there was an earlier plan.
plan was already submitted and still the GDA took no action on the same.
Therefore, you are permitted to file a new plan. Page 20, the order says that you are permitted, height of building, construction of building has been restricted by us. Respondent shall submit new plan to Ghaziabad Development Authority within 2 weeks. So whether such plan was submitted within 2 weeks.
That has not been annexed here with this application, but that was
File a proper application along with all this material.
then
You are the respondent before this court. Respondent number 1, so and so Buildwell Private Limited. So you were permitted to submit a map before the authority within 2 weeks.
that was very.
Authority was directed to decide your new plan.
It never decided
To show you submitted a plan within 2 weeks. Thereafter, we'll see whether the authority decided or not. You are not placing any material and then you are seeking prayer to grant liberty. By such liberty, then there will be a clear departure from the order of this court. We can't permit it. You place on record the material that as per the direction within 2 weeks you approach the authority with a new plan. Authority was directed to take a decision on new plan within 3 weeks. You will have to show that within 2 weeks you submitted, within 3 weeks authority either decided, not decided, permitted you to file the second map. And even if the authority permitted, within what stipulated period they permitted you to file a new map? Certainly not after 6 years. So this is not the way. So under the name of the other remedies, you would go before the authority with similar relief, which was then denied. There is some serious observation by this court that the plan was not according to the rules. The buildings were, proposed buildings were beyond the height, beyond the permissible height. No security measures were taken care of by submitting the map. All these are serious issues. A detailed order is passed by this court recording all these things. Where is that new plan?
Not sure it was on page 33, annexure A. Page 33.
33, sir.
Mitra.
This copy concludes, this application concludes at page 32A.
Lordship, page 33 of the PDF. I'm so sorry. Page 30 of the.
There's no 33.
Of the PDF page. I'm so sorry, Lordship.
You have the copy. You have the copy. Extra copy of
page
page
30
33.
page 30 of the paper book. Page 30 of the paper book. Apologies.
What is this? This is not the plan.
It has been submitted by the respondent number 1 at the right top owner, KDB Bilwell Private Limited. Has been submitted on 15/1.
With how many floors?
I'm not.
Tell us of the number of the floors in the proposed construction, proposed building construction.
I'm not aware of.
The copy, no PDF.
I was having the paper book copy. I apologize for that.
You are not annexed the plan. You are not annexed the decision of the authority. There is every reason, at least prima facie, that is something which the applicant is not coming with clean facts before this court. At the most, we will permit you to draw this application and substitute the application with better particulars. Then we only will permit you to withdraw that. The council at the outset submits that due to inadvertence certain documents are not placed on record along with the application and pray for two weeks time to file an affidavit with better particulars in support of the present application. 2 weeks time granted. Come with all this. Then list after 2 weeks.
May please, Your Lordship. In item number 1730, I'm requesting for
Restoration.
for SLP, Your Lordship.
There is delay of 213 days, madam.
The delay is caused because the petitioner, they come from a small town in Karnataka. So by the time we received affidavits, the delay kept on occurring, Your Lordship. We have been prompt in informing them about the affidavits which are required.
Now all the defects are cured.
All the defects are cured, Your Lordship.
For the counsel for the applicant petitioner, the submission is due to non-curing of the defects, the special new petition was dismissed. Subsequently, all the defects are cured, and as it requires some time to take necessary steps by establishing contact with the petitioners who are residing in the remote area of Athani,
Yes.
state of Karnataka, district Belgaum or Dharwad. State of Karnataka. Submission is the delay caused in filing the application is due to bona fide reasons and same be condoned. Of the submission of the council, the delay condoned, delay if any, filing application condoned, the petition be restored by
Grateful, Your Lordship.
Your Lordship, in this matter, I beg to appear on behalf of the petitioner. It's the restoration.
how much is the delay? You have filed separate application for delay?
Yes, Your Lordship.
How much is the delay?
Your Lordship, in main matter, 987 days, in restoration, filing restoration 105.
105?
Yes, Your Lordship. Initially, the petitioner is a rustic villager and she is a widow. Initially, this matter was entrusted with National Legal Service Authority of India, but the matter was not pursued, so it was dismissed default. Now all the defects are cured.
Yes, restoration application, the council submits that due to inadvertence, the defects were not cured within stipulated period. As such, the petition was dismissed. Subsequently, all the defects are cured. The council further submits that the petitioner being a lady in advanced age and An illiterate lady in her advanced age and not very conversant with legal proceeding was unable to provide necessary information to the council. As such, the delay caused in filing the application is for bona fide reasons. Of the submission of counsel, delay condone, application for restoration allowed.
Much obliged.
If I have
Restoration, defects are cured,
defects are cured.
132 days delay, separate delay application is filed.
Yes, fine. Everything is done.
Restoration application allowed, delay condonation, submission of the council that delay cause in filing application is due to bona fide reasons. Accepting the submission, delay condone,
Deeply
application.
obliged. I'm obliged.
733. Yes, 41 days delay. Restoration delay condonation.
There was one more defect pointed out by the registry with respect to the particulars not provided. Because that is already there in my restoration application, lecture A2, page number 8. Because the office reports that.
Office report records that defect.
Yes, my lords. Because that may not be required because.
Application defective that he has not furnished concerned trial court. So where are those details?
Lords, page number 8, annexure A2 of the application. So these are the particulars, my lord, with respect to the unserved respondents.
He has not furnished particulars of concerned trial court.
That may not be required because they were not served. So I was asked to give the fresh addresses. So I have provided the fresh address. These were filed with the registry. However, this got dismissed because there was a time frame given by this honorable court. And pursuant to that, I have also filed the spare copies for issuing of the notice. So these particulars are there, my lords. I may be also permitted to serve them to Dasti. If the lordship allows my application, I'll serve them to Dasti also.
But then why for the particulars of trial court?
I don't understand. That may not be required because the responses are to be served through their addresses. So I also don't understand as to why that objection has been raised.
No, but that was in pursuance to order by the Learned Chamber Judge 9922.
Unfortunately, I was not present. That's why there was a preemptory order passed and we couldn't comply within the time frame. So that was the only issue.
Wait, let us just see soon.
Yes, Mulus. Because that order is there at page number 6.
On appears and so appointed amicus passed over. Appears to see for passing the order. Taking state particulars of defect service. So now they are served.
So they get to be served now. Because I was granted 4 weeks time as a preemptory order. I received these very particulars lately. Immediately, very next day, I filed this very particular, but in view of that preemptory order, the special petition got dismissed. So thereafter, I moved this very restoration application.
No, but then you'll have to serve because order dated 25th January 24 permits you to serve through trial court.
So that's what I'm submitting. If Lordship allow my application today, give me liberty to serve them to Dasti through trial court. So particulars are there. I'll take the Dasti notices from the registry and serve them through trial court. Anyways, because they'll have to be served through usual mode and also in addition through Dasti, I'll serve them through trial court, my lords.
Yes, the Land Council. Mr. Notice was issued by the order dated 13/12/23. As the service of notice was incomplete, by the order dated 25th January 24, court permitted the petitioner to take fresh steps for effective service within 4 weeks, and in addition, the stay and service to trial court was permitted. Order dated 9/9/24, granting time was a conditional order, and as the petitioner failed to serve the respondents within stipulated period, the petition stood dismissed for non-prosecution. The Learning Council submits that by making necessary inquiries, the petitioner obtained the fresh address of respondent number 1, 2, 3, and 4, and these fresh addresses are supplied to the registry by communication dated 7th November 24. Copy of the same is annexed as Annexure A2. It is stated in the communication that respondent number 1, Sudesh Rani, is represented through her power of attorney holder Haripal, who is respondent number 2. Both are at presently resident of village Sagga, Tehsil, Nilokeri, district Karnal, state of Haryana. And 3 and 4 are pro forma respondents, residents of village Uchana, Tehsil, district Karnal, Haryana. The Learning Council further submits that the petitioner undertakes to serve these respondents by way of the stay service. As such, the objection raised by the office in respect of non-furnishing particulars of the trial court be waived. Accepting the statement of the council as an undertaking to this court, the application is allowed.
Still be restored minutes.
Sorry?
Not specially petition be restored minutes.
And allowed the SLP be restored to its file.
So grateful minutes.
Please, Your Lordship, this is an application for restoration. Defects has been cured.
Delay of 122 days.
Yes, Your Lordship.
What is the reason, ground?
Because we are not directly connected in contact with the petitioner because of language, linguistic issues. So we usually contact with a local advocate. So that's why meanwhile, when the order was passed, we have lost the connection with the.
Yes, restoration application, the council submits that the defects are cured insofar as delay of 120 days caused in filing the application. The council submits that due to certain language barriers, it took considerable time to establish the contact with council and to seek necessary information so as to cure the defects. Thus, the submission of the council is the delay caused in filing restoration application is due to bona fide reasons. Accepting the statement, application for restoration and application for confirmation of delay allowed, restore the petition to its file.
Grateful.
Worship, this is application for restoration. All defects are cured, my lord.
Within time.
Within time, my lord.
Defects are cured.
My lord.
All defects are cured. No delay. Application allows restore the file.
Grateful, my lord.
Please, my lords.
Yes.
As it
Its application.
Respondent short time to file reply to my IAS, my lords.
My lord, there is, we can argue in otherwise also, but there's 6 months delay in filing the application for substitution. My lord. That is the only ground with us, my lord.
That must have been explained.
No, my lord, they say they were in state of shock. The lady.
Where is that your application for delay?
They are applicable.
Point number 3, my lords.
Application 93132.
Yes, my lords.
What are these applicants doing in life?
These are the children of the disease petitioner number 2, my lords. The only information that they come from a very humble background, my lords.
What are they in life?
That I have to seek instructions, my lords. I am not aware of that.
Any occupation or agriculture is?
But I have to seek instructions, my lord.
Where is the order issued? The writ petition. Where is the copy of the petition? Where is the copy of your writ petition?
My lords,
They seem they are seems to be land agriculturists.
they are from a very humble background, my lords.
It's a council, they are all agriculturists. Not very conversant with the legal proceeding, legal niceties. Yes, condonation of delay application, the learned council. Sorry?
Price for 3 months only.
That's right, but the court can also consider the aspect that if there is a bona fide reason to condone the delay, then on condemnation of delay application, then a counsel submits it. How much is the delay?
200 days, my lords.
The delay of 200 days caused in filing the application is due to bona fide reasons. The learned counsel submits that firstly, the legal heirs of petitioner number 2, so is that the petitioner number 2 died on 24/6/23, and for some time the legal heirs were in a state of shock and sorrow. Secondly, the legal heirs being the agriculturists and illiterate agriculturists were not very conversant with the legal niceties. As such, the delay caused in filing application is due to bona fide reasons. Accepting the submissions, the council delay condone application of.
Deeply obliged.
Yes, 1 to 6 are represented to the council. Service of engagement of another council. 1 to 5 to 9. No one has entered appearance. You are for respond numbers?
Respondent number 4, my lords, MUHS. And for respondent number 6, my lord, National Medical Commission.
So 4 and 6.
If I may state, my lord, the last date, 7th March, order dated 7th March 2025. My lord has stated that there are 3 appellants who are unrepresented. Appellant number 3, 5, and 9. Last opportunity was given by the said order.
Order dated 25/11.
7th of March, 20 April, my lords. But if my lords may see,
March 2025.
if my lord may see the orders for the year 2024, they have been given ample opportunities. Nobody's has come up to represent these appellants. And this is a very old matter, my lords, 2011.
By way of last one more opportunity, it was adjourned on 7th of March 20. Middle of record reveals that. The appeal has been dismissed qua appellant number 3. Appeal has been withdrawn qua appellant number 2. And notices were issued to appellant number 1, 4, 5 to 9 for engagement of for alternate arrangement. And in spite of these notices being duly served, none represents neither the appellant are before this court nor they are being represented by any counsel. Who is respondent number 3?
It's Directorate of General Health Sciences and Health Service.
The office report, the record further reveals that notice for engaged alternate arrangement was issued to respondent number 3, and though notice is duly served, neither respondent number 3 is present nor is being represented by any counsel. You are representing 1 and 2 state of Maharashtra.
And for respondent number 5, MUHS methods.
5.
Maharashtra University of Health Sciences.
And what about 1, 2, 3 state departments?
I appear for respondent number 6, Madam. National Medical Commission.
None for respondent number 1, state of Maharashtra. Number 2, respondent 1, 2. Four. Council appears for respondent number 5, Registrar, Maharashtra University of Health Sciences. By way of order, it is 7th of March 25. One opportunity was granted to the appellants it seems that in spite of sufficient opportunities being granted to the appellants, they are not interested to prosecute the appeal. The appeal is of year 2014. This is about the allotment of seats of the bomb. They all were admitted in the MBBS course in year
The year
2010.
My lords, they were admissions are in the year 2004. They were required to sign bonds after completion
Of their course.
That provision was being challenged before the High Court.
And the petition was dismissed. That the even all India quota students will have to submit that bond.
By the coordinate bench of the High Court. What has happened, my lords, when this court, honorable court, issued notice, they had directed, the High Court had directed them to deposit an amount of 5 lakhs. Even this honorable court, while issuing notice on 14th September 2011, had directed them to deposit rupees 5 lakhs, and which was supposed to be kept in a fixed deposit for a term of 1 year. Now it is for the petitioners to inform what has happened subsequent thereto about this.
But they are not coming out of this course. By way of last opportunity, time was granted. On 7/3/25. If they would have been interested in prosecuting, somebody could have appeared. So that no, it seems no, they are not interested in dismissal. The most we can say that the petitioners were admitted to MBBS course in year 2004. The order impugned in the SLP perusal of the order impugned in the present SLP reveals that the petitioners were admitted to MBBS course sometime in year 2004.
Admitted in the year 2004-5 for the batch starting, and they passed out in 2009.
Admitted to MBBS course in year 2004-5 and completed their course
2009. And also will find this at page B of the synopsis, my lords.
B
of the synopsis.
of the petition, so that the petitioners were admitted in MBBS course in year 2004 and completed their course in 2009. The respondent state authority asked these petitioners to execute bond pursuant to the government order dated 8th of February 2008, government resolution resolution, government resolution dated 8th of February 2008. Being agreed by the said direction, a challenge was raised to the government resolution dated 8th of February 2008 before the High Court of Bombay. By filing writ petition number 4849 of 2011. By the order dated 9th August 2011, the division bench of the Bombay High Court, relying on the judgment in writ petition number 2176 of 2010 dated 5/4/2011, found no merit in the petition. Resultantly, the petition was dismissed. Considering all the above referred aspects, it can safely be said that the petitioners might have lost their interest in prosecuting the petition. As such, they are not before this court. The petition is accordingly dismissed.
Obliged.
Notice for alternate arrangement is duly served on the sole respondent, but neither the respondent is present nor is being represented by any counsel. To give one more and last opportunity, least after 2 weeks.
इसलिए छोटी सी एप्लीकेशन बनाई आपने
Service is incomplete. Section number 2, 20 to 22.
Requesting for 4 weeks' time.
At the request of the council, 4 weeks time granted to take necessary steps for effective service on unserved respondents. Fresh particulars are not filed by the petitioner, as they said, the respondent has not filed fresh particulars. You are representing whom?
For the respondent number 1.
One. Fresh particular respondent. Thank you. Good. And for petitioner, why they ordered it? At least after 2 weeks. Yes,
My lords, I'm appearing for petitioners in this matter.
Recall.
My lords, I have been there has been a defect, and I was granted some time to cure the defects, but I could not connect with the client, as the court fees also has to be paid in this. I am seeking one more opportunity if may be granted, so that it can be cured and can be listed. There has been
time was granted on 14.
my lords.
Now this matter is listed. So you got already 4 weeks time more.
My lords.
Stipulated period of 4 weeks.
My lords, I am just praying for 2 more weeks so that I can.
To comply the office report dated 6/7/23.
My lords, there has been a change.
The matter was listed before the register, before the learned chamber judge for more than 3 occasions.
My lords,
So why additional time be granted to you now?
My lords, there has been a change in the AOR, and this is an matter where organization is concerned. So
organization is not at a different level than
My
any
lords.
other party. Same treatment to organization.
I bow down to my lords. My lords, I'm just praying for 2 weeks, else my lords may give a conditional order if my lords may please. The court fees has to be paid as per the office report, and for the court fees I could not connect with the client, and the court fees could not be released by the organization.
You are seeking recall of which order?
My lords. I have filed the review petition. An AOR filed the review petition, which was also dismissed. The review petition was dismissed. Then I have filed an application to recall that order and
Where is the order on review?
my lords. One 10581 of 2024 is the review petition, my lords. Of 23.
So your review was dismissed with the cost.
My lords. Review was also dismissed as the earlier AOR could not comply with the.
Time now. Sufficient time is granted to you.
I bow down, my lords. Only a request that a conditional order may be given, else.
Why? Look at your approach.
My lords, I have mentioned that for the court fees, but the organization could not release it.
You were permitted to avail the remedies. Without being there any liberty granted to you, a review application was filed, aspirations are cast on so and so. That review petition was dismissed. Instead of challenging that order, you filed SLP in this court. When this court apprised the council that this is not a proper way, you ought to have filed, challenge the order in the review petition. The council insisted, refused to listen the bench.
It was some other, my lords, council.
Maybe.
Then I have been engaged. Like,
But that by changing council, you can't seek the recall of this order, which is detailed order passed by this court on 10th of February 23.
my lords.
By way of present application, the applicant pray for a recall of the order dated 10th of February 23. The division bench in its order dated 10th of February 23 was pleased to observe that while dismissing the petition by the order dated 10th February 23, the division bench made following observations. Take page 7 from last para, learned counsel, at the inception, from that second para at the inception, so and so. Whether the cost is deposited?
No, not now, my lords.
Oh. Now, so the petitioner was to, now in pursuant to the order of this court dated 10th of February 23, the petitioner was to deposit cost of rupees 20,000 within stipulated period of 4 weeks from the date of order. Admittedly, the cost is not deposited within stipulated period. The application seeking recall of the order is filed on 25/4/24. While the order dated 15/10/24, the learned chamber judge granted 4 weeks time to cure the defects. As the defects were not cured, the matter was listed before the learned chamber judge on 29/11/24. Conditional following order was passed on 29/11/24. 2 weeks further time and no more is allowed to the counsel for petitioners to remove the defects. In spite of time being granted as a last opportunity by the order dated 29/11/24, the defects were not cured and the matter was listed before the learned chamber judge again on 14 February 25. By the order dated 14/2/25, at the request of the counsel for the petitioner, 4 weeks time was granted to cure the defects. And now the matter is listed today. That's on 15/4/25. And even today the council pray for further time to cure the defects. It seems that the applicant is not serious in prosecuting the application. The above referred sequence of events clearly show that the applicant is not interested in prosecuting the application. And there is no justifiable reason to grant further time to the applicant. The application deserves to be dismissed. Name is accordingly dismissed. None. So the parties after 2 weeks. Hookers Fund.
Yes, Your Lordship. I am appearing for the appellant in this matter, Your Lordship. Your Lordship, the appellant company has undergone insolvency and it has been confirmed by the Honorable Supreme Court as well. I will file the relevant orders of the insolvency, Your Lordship. Now, at this stage, I am not authorized to file any application because the RP has taken over the control of the company.
The appeal is dismissed.
Your Lordship, Your Lordship, yes. Your Lordship,
So
the matter was settled.
As per the rule, if the appeal is dismissed, interest fund amount would be refunded to the appellant without interest.
Yes.
Dismiss, the same will be allowed to be withdrawn by respondent.
Your Lordship, actually in this case, the appeal was not dismissed, it was settled. The matter was settled between the appellant and the respondent, and thereafter it was disposed of.
The appeal is dismissed on merits, being divided on merits.
Your Lordship, in that case, that is why I'm submitting that the matter has been settled between the parties already, and the Honorable Supreme Court was also intimated about the same. And that is why the withdrawal has not been made on our part, because in the meantime, the company had undergone insolvency. So now the appropriate application cannot be made by us, and since the RP has taken the control of the company.
But the court order is not recording that it was due to the parties have arrived at some compromise or some settlement. The order is clear, dated 6/10/23. Appeal stands dismissed being devoid of any merit.
Your Lordship, I agree, but that is why I'm saying, because the company in the meantime had undergone insolvency, so now I cannot file any application. The appropriate application can only be filed by the RP, who has taken the control of the company. Now at this stage, I can't file. That is why I can only file the relevant orders of the NCLT, NCLAT and Supreme Court.
Again, if the signed order is used, there is no reference to any settlement between the parties. We are of the considered opinion that NCDRC has given just and valid reasons for conclusions arrived at. We see no reason to interfere with well-reasoned order. Appeals can dismiss being devoid of any merit. In that situation,
Your Lordship is right. Your Lordship is right. But after that, there was a settlement executed between the parties. The whole
thereafter anything might have happened. We are not concerned with that.
Yes, I agree, Your Lordship.
On merits, as per the rules, if it is dismissed, the respondent is entitled to get the suitor's fund amount.
Yes, Your Lordship is right. That is why I am submitting that, because now the company has undergone insolvency. This subsequent factor settlement.
You are for the appellant company.
Yes.
Appeal is dismissed. You have no role to play. Even if
Your
it
Lordship,
has undergone liquidation, it hardly makes any difference. Your appeal is dismissed on merits. The suitor's fund amount, the respondent can validly claim it.
Your Lordship, my submission is the disputed amount between the parties was already paid to the respondent. That is why now I cannot file any application.
That's a different matter, madam. But while filing appeal, you must have deposited some amount.
Yes.
Now, order is to be passed on that amount, which is the suitor's fund amount.
Yes, Your
Lordship. As per the rule, if appeal is allowed, the appellant is entitled to get that amount.
Yes, Your Lordship.
Appeal is dismissed. In that situation,
the respondent
is entitled to. If both are not coming, or the appellant has no role to play because the appeal is dismissed, respondent has not filed any application.
Yes, Your Lordship. Your Lordship, that is why this is the reason.
Court can pass the direction for disbursement of suitor's fund amount.
Your Lordship, for disbursement of suitor's fund amount in favor of respondent, that is why I am objecting, because the matter was settled.
You can't object.
Your Lordship, that is why.
No role to play once the appeal is dismissed on merits.
Your Lordship, I agree, but that is why I am saying, because the appropriate application is to be filed by RP now. Now I cannot file the application because the company, now to bring on record this fact that the matter has been settled and the whole disputed amount has been paid.
RP is not coming before this. The court can exercise its discretion as per the rules.
Your Lordship is right, but notice may be issued to the RP so that he may appear before this court and then take appropriate action.
They ought to have come before this court.
Your Lordship, because this was a disposed of matter, so might be that RP is not aware.
We are not in agreement with your submission. The court granted some time. If somebody comes before this court, files application, sufficient time was granted. Nobody.
Your Lordship, the Supreme Court order admitting the insolvency is on 2nd of January. That is why after the Supreme Court
Notice was issued to the parties
on 7th, 11th.
It is duly served on the parties.
Yes, Your Lordship.
Okay, we'll record your submission.
Your Lordship, that is why I am saying that after that the insolvency was confirmed. That is why now the RP has to file the appropriate application. I cannot file.
Right, if he is not coming before this court, are you expecting this court to go to the RP and request
Your Lordship.
application?
No, Your Lordship. Actually, the service was done upon the earlier council. That is us. Now, because the RP has come into the picture, now he is not aware of this.
You make him aware. You have some.
I will. To some time maybe. I will, Your Lordship.
When post decision of this court, when the matter was settled?
Your Lordship, I don't have the exact date of the settlement because now the whole company.
Is it now for this court to wait to the parties to approach this court at their leisure?
No, Your Lordship, I'm really sorry. Your Lordship, no, Your Lordship, I'm sorry. That is why I'm saying some more time may be granted and the RP will inform the RP, he may take the appropriate steps accordingly. Yes, Your Lordship.
Is this court is obliged for receiving an intimation from RP or to send the invitation to RP?
No, Your Lordship, no.
Then?
Your Lordship may give us some time. I will only inform the RP if he wants, he can take the appropriate steps. Otherwise, my Lord may proceed and pass an order on the next day.
Who had an order dated 7/11/24. The following order was passed on 7/11/24 by the learned chamber judge. The office report dated 3rd of April 25. Perusal of the office report dated 3rd April 25 show that the notice has been duly served notices have been delivered, but the learned counsel failed to counsel for respective party failed to file any application for withdrawal of suitor's fund amount. It may not be out of place to refer to the relevant rule in respect of disbursement of the amount, that is suitor's fund amount, and the rule 24, order 24 of rule 7 of the Supreme Court rules of 13 reads as under. If the appeal is allowed by the court, the amount deposited by the appellant will be refunded to him without interest, but if it is dismissed, the same will be allowed to be withdrawn by the respondent or may be disbursed as per the direction of the court in that behalf. The perusal of the order dated 6th October 23 in civil appeal number 6520 of 23 show that this court could not find any reason to interfere with a well-reasoned order passed by NCDRC dated 20th December 22, which was assailed by the appellant in the said appeal number 6520 of 23. The division bench, by recording that appeal they dismiss the appeal by recording that the appeal is devoid of any merits. The counsel for the appellant submits before this court that post the decision of this court dated 6th of October 23, the parties arrived at an amicable settlement. The Land Council further submits that the appellant Yes, what are your instructions, madam?
Your Lordship, I am seeking some time because I will inform the RP, he will take the appropriate steps.
What are your instructions that subsequent the parties have settled their dispute and the appellant company
Has undergone insolvency, Your Lordship.
and the appellant company has undergone insolvency
After dismissal of appeal,
and the affairs of the company are now being looked upon by the resolution professional. The learned counsel pray for some time so as to apprise the RP so that in turn the RP may file an appropriate application for disbursement of suitor's fund amount. How much? What was that amount of suitor's fund?
Your Lordship, around 50,000.
Once your appeal is dismissed, how you can hold this amount by asking the RP to file application?
Your Lordship, that is why I am apprising, because the service of this notice which was served on us, this was before the company went into insolvency.
That's right. Therefore, post decision events, this court may not take into consideration. As the rule provides, application is not filed, your appeal is dismissed, you are appellant, you can't hold the amount. At the most, it could have been the respondent, that is a private party, who could have approached this court and asked for suitor's fund amount. He is not coming before this court. In that situation, even the RP is there. On behalf of RP, you can't allow this court to, request this court to hold that amount.
Your Lordship, I am not requesting to hold this amount. I am only requesting that because the matter has been settled, the respondent is not coming because it is settled and the whole amount has been disbursed.
If he is not interested, not interested. We'll direct to deposit this amount for a better cause.
Your Lordship, that is why I am saying because the matter was...
Leave it to court.
Your Lordship, because the matter was settled on these terms only, that the suitor's amount shall be refunded to us.
If the respondent is not, he is duly served.
Your Lordship, that is why I am requesting some time. If it is in the hands of the RP, he may file an appropriate application.
He may not. Even if he files.
Yes.
In no case his application will be allowed. So why to hold this amount? Let it be utilized for a better cause.
Yeah, Your Lordship.
In my opinion, there is no justifiable reason to permit the RP to approach this court for filing an application for disbursement of suitor's fund amount. As per Order 24 Rule 7, in case the appeal is allowed, the appellant would be entitled for refund of the amount without interest, and if appeal is dismissed, the respondent will be permitted to withdraw the amount now. In the present case, admittedly the appeal is dismissed. The respondent is made aware of the notice is issued to the counsel for respondent. No issued, and the same is delivered to the counsel for respondent. Till date, no application is filed on behalf of the respondent. As such, in my opinion, the third course open as per the rules is the disbursement of the amount as per the direction of this court. Accordingly, registry is directed to which is this advocates fund or this Supreme Court advocates fund or something like that. Advocate Welfare Association, Advocates Employees Welfare Association. The registry is directed to deposit the said amount in the accounts of Supreme Court Employees Association within 2 weeks from today.
Much obliged.
You tried your level best.
Yes, Your Lordship. Much obliged.
Again, suitor's fund. But it's just least after 2 weeks. 7, 4, 5. Again, you have not filed application for least after 2 weeks. So and list of to be.
This case, Your Lordship, I've taken 1 week time on the last date of hearing to file an appropriate application. Now, the application is ready and it's in transit.
1 week?
1 week, one week.
At the request of the council, 1 week.
Please, my lords. My lords, all these matters are granted 8 matters. So we have requested the privately aided college to provide the particulars, my lords. We have still not received the particulars, my lord.
4 weeks time as the last chance.
6 weeks it may be granted.
Okay, at the request of the council, 6 weeks time granted as a last chance to submit, to provide the necessary details.
And also, my lords, the application to bring the LRs of the deceased respondents in 174.8.2 and 3, my lords.
But you will have to take steps first, no?
Please, my lords, please.
So take steps.
Please.
Consider the application. 6 weeks as time as a last chance
Please, my lords.
to take appropriate steps.
Please, my lords. Grateful, my lords.
Is it point 1, sir? Point 1.
For the petitioner, sir.
1749. 1.
Lordship, I seek some time for completing service for the unserved respondents.
How much time you want?
4 weeks, Lordship.
Okay. At the request of the council, 4 weeks time granted to take steps.
This matter, my lord, we have already complied with the office report, my lord, but your lordship, just the last paragraph of the office.
Service is not complete.
Yes, my lord, we have submitted spare copy along with the press particular of the respondent number 2. Since the ST has not issued the notice because there is some delay, my lord. So lordship,
So it's only delay or details are not, I mean the sufficient details are not provided.
Lordship, just see first page of the office report, my lord. Last 4 lines. Office report, my lord. May I hand over it, my lord?
Wait, please, let us see.
Last
Application to the.
Last 4.
One has file counter
Yes,
affidavit.
last 3 lines, my lord.
Wait. On fresh particulars in respect of to process the matter. So that on fresh particulars along with spare copy of beyond the time granted.
Yes,
So how much time was granted?
Well, the time was granted on 21st November 2024, my lord. Last order it was noted, my lord. So 28 I have filed, my lord. Before that, my last opportunity was granted to me to comply with office report. My lord, here, my lord, we didn't receive the address from the petitioner, my lord. So that's why there was some delay, my lord. Now everything is complete, my lord. Lordship may kindly issue notice so that matter can be proceeded further, my lord.
The council submits that. Where you ordered it at 21st November 24. When was that last opportunity granted to you? It's only
The last opportunity was granted, my lord.
Despite last opportunity granted.
My lord, on 20. Granted on my lord.
May I submit, sir?
My lord, on granted on 18 September 2024 by the chamber, by the learned registrar, my lord. 18/9/2024.
18/9, yes, take steps particulars.
Last 2 lines, first 2 lines, my lord.
No, but it's 2 weeks time.
Yes,
2 weeks time on the record. Oh, so at least you were supposed to file these fresh particulars within 2 weeks post the order dated 18/9.
Yes,
you have submitted those particulars on 28/11.
Yes, my lord. Your lordship may just see what had happened after that, my lord. The final may I read the whole order of 18th September? Learned counsel for the petitioner is granted 2 weeks time as a final opportunity to take fresh steps and file fresh particulars in respect of the respondent number 2, my lord. Actually, what fresh particular was not available with me, my lord. That's why, my lord, there is some delay. Now it is available with me. We have already filed, my lord. And
so how you explain the delay? That's the only difficulty.
Delay, your lordship may permit me, we will file applications.
Orally, you tell us.
Orally, my lord, we have already sent this information to client, my lord, but he was not available at that time, my lord. So,
What is the address of your petitioner?
Lord, it is there, my lord. Let me just see page 11. Page 11, my lord.
The counsel for the petitioner. Villain counsel submits that by the order dated 18/9/24, 2 weeks time was granted as the last opportunity to take fresh steps so as to file fresh particulars in respect of unserved respond number 2. As the fresh particulars were not supplied, the matter was listed before the learned registrar on 21st November 24 and following order was passed. Respond number 1 has filed counter affidavit despite last opportunity having been granted. Counsel for the petitioner has neither taken fresh steps nor filed fresh particulars in respect of respond number 2. Registry to process the matter for listing before the Honorable Judge in chamber for necessary direction. In counsel for the immediately thereafter, on 28/11/24, the fresh particulars along with a spare copy, fresh particulars of respond number 2 along with spare copy were submitted to the registry. The counsel further submits that though there is some delay in supplying the fresh particulars, the delay was due to bona fide reasons, namely communication gap between the counsel and the petitioners who are resident of a remote village in district Gurgaon. The counsel further submits that this delay being for bona fide reasons can be condoned, and as the fresh particulars are now submitted to the registry, notice we issued to respond number 2 on their fresh notice we issued as per the fresh particulars supplied to the registry. Accordingly, the delay was in supplying people in providing the fresh particulars is condoned. Or registry to issue fresh notice to respond number 2, making the same return within 4 months.
May I submit? Counsel for respondent number 1.
In the earlier matter, 1750.
Yes, sir. Yes, sir.
You are for respondent number 1.
Respondent number 1. They are giving false submission, Honorable Sir. And I was listening very carefully. How they are misleading the Honorable Court.
Your application is pending.
I am counsel for
Respondent number 1.
Your application for to appear in person is pending.
No, Your Honor, my no such application is pending.
Are you permitted to appear in person?
No, Your Honor, I'm counsel for the respondent number 1, Lalit Kumar Sharma, and AOR is also present through VC, Varun Singh, Mr. Varun Singh.
Sir, come physically file your reply to the petition. What's there? File your reply.
No, Your Honor, I want to make submission before this.
You are representing respond number 1. You are a counsel for respond number 1.
Yes.
So file your reply. Where's the question?
You know, actually, this is happening way long back in 2006, and it is their intention to linger on the matter.
Counsel,
And how
is there any prohibition to file response? Reply?
You know, I have not yet received any copy. Not yet received any copy. How I will file the reply?
Unless you file a proper power wakalatnama, we can't hear you. And if you have filed your power, you file your reply.
You know, Mr. Varun Singh, AOR is also present, and he has filed wakalatnama.
So if you have filed wakalatnama, file your reply. Who prevents you?
That's okay. With respect to
I have not received any copy.
Where is your error? Where is your error? Where is your error?
You know, they are.
We are trying to tell you.
They are trying to delay the matter. Honorable sir, this is matter pertains to the year.
Are you practicing lawyer? Are you practicing lawyer?
Yes.
Where is your error?
Yes, sir.
Where is your error?
He is present through VC. Mr.
Yes, Mr. Error. Mr. Error. Is there any prohibition for filing response?
No, not at all.
Sir, you are there on record as advocate on record.
Yes, madam.
Are you aware of the practices of this court?
Yes, madam. Yes,
Is this right?
That's definitely will file the reply to that application.
Is this a way to address the court when you are there?
Well, it's definitely will file an application.
So we are permitting it. We are permitting you to file response, reply, whatever you want to say. Even you want to say that the petition is wholly untenable, you are free to make that submission in your reply, counter affidavit.
Yes. May I kindly submit my counter we have already submitted.
We are permitting you.
Yes, madam. With respect to any other application, we'll file the reply.
Whatever response either to petition, application, you are a party to petition. If you have filed your power, you are authorized to file your responses.
Yes.
This is as simple as that.
Definitely we'll do that.
Why your party is insisting on all this?
Why? My that's only small.
I would apologize. You know, I want to submit this thing because I'm the witness how they are lingering on the matter. So it is very. This is also a tactic.
Whatever he wants to say, he can say through the response.
We'll do that, my lords. Only
it's a proper way.
Only why?
No purpose would be served by this dialogue on VC.
Yes, my lords, we'll do that. Only to this related.
For the learned or for the response number 1, pray for some time to file response reply to the petition. 4 weeks time granted to file reply, response, counter affidavit, whatever it may be, the petition. Please.
Only submitted related. One respondent, number 2 relative. So that matter through this only. The service is not affected. That was only.
There is some disturbance in audio also.
No worries, madam.
Not clear. Better you come before this. Reply. We'll hear it.
If this honorable court may kindly appreciate the material fact that both are relatives, both are Jija and Sala. So, and this is the thing which is happening, and they are considering this fact, material fact, before the honorable court. And I have both of them.
Mr. Counsel, whatever you want to say, file your reply or come before this court physically. Yes.
Sir.
Only this will take 1752.
Yes, my lord. In 1751, I am appearing, my lord. Kindly grant me 4 weeks time to comply with the order.
No, you have not filed the proof of surrender.
My lord, I understand, my lord. I just want a final opportunity. I'm not able to contact the petitioner, my lord. Just give me one more
2 weeks
opportunity.
only 2 weeks, not 4 weeks.
Please, my lord.
You're bound to surrender 2 weeks. Yes, at the request of the council, 2 weeks time granted as a last chance to file the proof of surrender. Yes, 1752.
I'm seeking 3 weeks time to cure the defects.
At the request of the council.
Petitioner. Appellant.
For petitioner, 3 weeks time granted to cure the defects.
Obliged.
Deeply obliged. Pass over, ले लीजिए.
It's a transfer petition and a check bounce case. The check was issued in Chennai and
Negotiable Instruments Act. Notice 4 weeks.
stay Manoj mean.
Negotiable Instruments Act.
I mean I have to
Yes,
come for
yes.
the bail bond.
Let the other side come.
I have to come here for the bail bond issue. Bail bond, Manoj. I have to take a bail bond in the Saket court. I am having some health issues which I could.
You can request the court for this
They've asked for the stay order.
Exemption of your personal appearance.
Yes, they've
on
asked
your
for-
health grounds.
We have submitted it. They asked for the stay order from Supreme Court.
2 weeks. 2 weeks.
4 weeks.
We'll make it returnable 2 weeks. And petitioner even on second call, list after 4 weeks.
Lordships, may I mention 1622? Due to my non-appearance, Your Lordships, the matter has been posted after 4 weeks. Your Lordships, in the connected transfer petition between the same parties, notice has been issued only for the purpose of mediation. The office report also says so. Your Lordships, same order may be passed.
Notice to be tagged along with so and so.
Please, Your Lordships. Obliged.
With my lord permission, there is supplementary matter 1754. I'm appearing for the petitioner, my lord, here.
1754 we are not taking up. We have taken up only up to 1752. Rest of the matter will be listed.
My lord, just one short submission. In addition, we want a dusty to serve the respondent number 3. Rest of the respondent has already been served, my lord.
What about the service on respondent number 3?
Yes, my lord, the thing is like that.
There's on record the screenshot of email.
My lord, let me clear it. The notice was issued after that. No proper office report was generated, my lord. The address is of Accountant General Jharkhand. One typographical error was there. That Jharkhand was not mentioned. Apart from that, the address is same. But no office report. On last date, when I appeared before the registrar, it was said, okay, we will take it at the end of the board. I said, if allow me, Dasti has not been given to me. If my lord
to somebody whose city is not mentioned.
My lord, the
Somebody
Doranda Ranchi is mentioned, except one word, that was Jharkhand. Rest of all the petitioners are from, respondent are from Jharkhand. His Accountant General Jharkhand, Doranda Ranchi with proper pin code is mentioning. But in addition, we are seeking Dasti because we will serve them through mail and I will file an affidavit of service, my lord. The service will be complete on respondent number 3. The whole situation arises just because, my lord, I want to point out the registry has not till today also there is no office report on this. On last day also there was no office report. Then how could an AOR will get what was the reason for not serving the respondent?
Let us just see. If you are raising some objections that the registry is not quoted or noted, let us also see what is 1754. What is under challenge?
My lord, it's about a pension. It's a pension issue. The whole thing, the Succession Act was the deceased was a Christian.
Respondent number, who is respondent?
Respondent number 3 is Accountant General.
Accountant General
Jharkhand.
District Karachi. That is the same address which
Yes,
is
sir.
in
Doranda,
SLST.
Ranchi, there is same, pin code is same.
Wait a minute. Why are you in hurry now? And what the office report shows, until so not happened despite of last opportunity. Where is that objection about Jharkhand? It is only objection that you have filed a submitted screenshot of service.
Kindly come, this is the last order of 26th of March. Before that March, before that last opportunity, that was the first opportunity and it was been written as last opportunity.
Not delivered because of insufficient address.
Yes, my lord, the only insufficiency was the Jharkhand one. But
From where do you get that?
My lord, I have gone through the proper, like there was no office report. It was mine. This is the, because if my lord may give 4 weeks or 2 weeks even, and in addition, Dusty, I will serve it and file a proper affidavit of service, my lord. Four weeks time should be given to me. And in addition, Dusty should be given to me to serve the respondent number 3, madam.